Yes.
My lord, may I be permitted to mention, my lord?
Yes.
One is, my lord, the listed matter 67 and 69.
Yes.
But these are two very matters are urgent. If it is not taken up today, my lord, can it be taken up tomorrow itself? It's a very tender matter, my lord.
Oh, this is that IOCL, that
Pardon me?
that IOCL, that trucks.
HPCL, residuary matters.
All right.
And my lord, another matter I am just mentioning, my lord. This is, my lord, very public interest is also involved. We are the voters of that constituency, my lord. Boshirat MP, my lord, expired more than 9 months or 10 months. Election Commission has not yet declared the date of election in the matter. My lord, we have filed the petition. Petition is pending. But this is a very urgent matter because we need our representative in the parliament.
You have waited for 9 months. You can wait for 4 days, 5 days more.
4 days.
Not this one. The other one, I'll list it tomorrow.
But
That's subject to Lordship's can sanction or extreme urgent motion. Lord, determination of Honorable Justice Amrita Sinha. Lord, I will move it before your Lordship
Mr.
on Monday.
Bandapade, give your slip.
Yes.
Give the slip for item 60.
69. 67 and 69.
Maybe it can come up today. How do you know it won't come up?
No, if it is come up today, I will do it. Unless I am stuck.
Hopefully, maybe. Hopefully, it will come up. Maybe.
Oh, very nice. Then it's no problem.
Generally, we are able to
Very nice.
match that speed. Let's see.
But then it will be very good days for our this bar.
We are not.
We want a very speedy
Not any
disposal.
good.
Everyone is there. So we are very happy that if this is
Let us
really
see
the way this
if we can reach. If not today, then tomorrow. Definitely.
It's all right. We are very happy the way your lordship is taking up the matters.
Yes,
Great
Lord,
work, your lord.
I want to move it on Monday, my Lord. Extreme urgent motion of Honorable Justice Amrita Sinha, my Lord. Lord, my account will be freezed.
Tomorrow is original side, sir. What is
Monday?
what is the urgency?
Urgency is, my Lord, by Tuesday next, my Lord, my account will be freezed without assigning any reason. My Lord, they have raised a demand of 8 crore in a cash credit, my Lord.
It's a surfacey matter.
No, my Lord, it's not a surfacing matter because there is no proceeding. My Lord, bank guarantee matter, my Lord, that is for such reason, Lord, I have come before.
Bank guarantee in a contract.
My Lord.
Bank guarantee in a contract.
My Lord, absolutely.
So they are forfeiting your money.
My Lord.
You have not performed.
No, my Lord, I have performed. My Lord, I have enlarged my case, my Lord, in the writ petition. My Lord, on Monday.
Your Lordship, may I be permitted to mention,
Yes.
my Lord, one urgent matter, it is also relating to tender, my Lord. If for inclusion in your Lordship list, otherwise it will be infructuous, my writ will be infructuous.
When is the tender open?
My Lord, tender, my Lord, I am the successful bidder. I am continuing with the work. Certainly without any notice, my tender was cancelled and it was opted for the other one. Without any notice, no hearing, nothing. My Lord, kindly.
With your matter relating to the
Class is constructing the unauthorized construction and obstructing my ingress and egress. But I am praying that the upgrade is matter is running in the list. Lord, I praying that
My Lordship, kindly, my Lord,
domination
on the original side matter, my Lord. Item number 28 of the original side list, which has been published as advanced list today. Lord, 28, item number 28 in the original side. But this matter, my Lord, pertains to one interim relief is there with regard to cancellation of plan. Lord, the proceeding hearing tomorrow is.
You smashed his mic.
Sorry.
My Lord, tomorrow the cancellation of. It's all right. Tomorrow, my Lord, the cancellation of plan proceeding is fixed at 4 p.m. So, Lord, if this matter can be given some precedence within 5 matters or
Item 28, it's perfectly fine, sir. It will come up. It will come up tomorrow.
my Lord, in case, my Lord, it does not come up, may I mention at 2 p.m., my Lord.
We'll see that.
My Lord.
for upgradation. The petitioners are the bona fide tenant of the building without giving any notice of demolition. It is for the municipal demolition work, and my Lord, they will start demolition work at any time.
My lord, the petitioner has applied for renewal of his passport, my lord. For the last 2 months, my lord, his passport is not getting renewed. Now, my lord, there's no response also why it is not getting renewed. My lord, he has to travel to Singapore, my lord, for his business.
When?
My lord, from 17th of May of this month, my lord, why, my lord, we need visa permission.
Why here?
My lord, why here, my lord? Since, my lord, if I don't get my passport now, my lord, I will not be able to apply visa for Singapore.
Singapore, 3 days.
My lord, I would
3 days.
very well, my lord, I can only.
Lord, Lord's kindly to mention one matter, Lord.
Item number 242, my lord.
Yes,
242.
wait a minute, wait. Yes, tell me what?
Or item number 242, appearing in the
Yes.
list, my lord.
Yes,
Well, unauthorized construction is going on
very good,
without leaving site space,
very good.
which damages my building.
All right. Claim damages,
Alert.
nothing, no urgency. It will get demolished. Yes. Just a minute, madam. Yes.
Lord, one tender matter, Lord, from Justice Sinha's determination. Lord, this is tender for procurement of bed sheet in railways. Lord, in all earlier times, the bed sheets were being procured, Lord, from Khadi and Lord MSME. Now, this time, they have put in a clause in the tender that MSMEs could not even participate in violation of the government policy. Now, my lord, that is under challenge. 28th is the date of Lord closing of the tender. We have challenged the conditions, may it appear tomorrow, my lord, I shall serve notice and come back. Lord,
Your lordship, may I be permitted to mention one matter for arbitration?
Just a minute. Hear it out. Wait.
Your lordship, this
Sir,
is
I'm here. I'm not going anywhere. What is the?
your lordship, this is a construction of illegal business. Now, plot where the commercial building is being constructed, it is only suitable for a single-story building, but a G+3 story building is being
Very good. Let
constructed.
it come up. It will get demolished. No urgency. Yes.
50 of your lordship's list. Lord, Friday,
Your
my lord,
lordship,
the
it is
date
in the
fixed
list
for
since-
demolition. Friday. Lord, no notice has been given to me. Despite that, Lord, demolition order has been passed, and Lord, Friday is fixed for Lord
I hope
demolition.
not like yesterday's case.
My lord,
I hope not like yesterday's case.
Lord,
Yesterday, the matter which you had argued.
Lord, I did not argue any matter yesterday. But yesterday I
Not,
never
okay,
appeared.
not okay. Not yesterday. The earlier occasion. Yes. So
Lord,
what is it? Demolition?
Lord, Friday. Friday is the date fixed. 150. Item number 150.
156 and
156.
one more matter, Lord, only.
Yes.
Order has been passed by the first committee, which is the identification committee. On 15 this time, my lord, the review committee can, my lord, review the order and pass the final order. I have challenged the first committee's order on the ground that the show cause notice was issued under the 2015 circular, order passed under the 2020.
So you challenge the second committee report also. What is the urgency in this?
The urgency is, my lord, before the first committee, I have a right of hearing under the 2015, my lord, guidelines. Before the
Yes.
second committee, I have no right of hearing, my lord, under the circular. That is the urgency, my lord. They can pass order any day, my lord, my writ becomes infructuous. It's an original site matter, any day, my lord.
Lord, 156 and 157. 156 and 157 interim order is expiring tomorrow.
Order.
Yes. 156, 157.
Inclusion.
156, 157.
My lord, may I have your lordship's kind leave?
Just a minute. Just a minute.
I'm so grateful.
Yes, madam. Just a minute. Yes.
And it takes better, but twice back had notice, public notice, twice third time notice, we were not very obscure newspaper. Now we come from that scene has been concluded, and we're asking him to cut the third party rights to creative lordship. The bank, so the RTC says we are intending buyers, they have been pursuing with the bank. Bank has clandestine gone forward and won't get one single person, favoring that one single person.
Lord,
Similar incident, I original site, but not the original site.
Original side.
My lord, I did not participate in the bidding. Later on, I also came to know that the same property. I
Take it.
Lord, an application for inclusion in the list of application for recalling. Lord, application for recalling of
There's
your
no
lordship's
urgency
order, Lord.
recalling application, sir.
My lord, may I have your lordship's kind leave?
by the local government, who is the owner of the property. In case an
No urgency. Unauthorized. No urgency. Unauthorized.
Lordship, new motion.
No unauthorized. Yes. Very good. It will get demolished. Yes.
Land is one kata and that's all.
Very good.
And it has been constructed G+3 building.
It will get demolished. Very good, sir. It will get demolished on its time.
Lordship, new motion.
My lord, may I have your lordship's kind leave?
Yes.
To
Which matter is this? Yes. Take it.
Lordship, new motion for inclusion, Lordship. Lordship, may I be for new motion? My lord, may I mention a matter, my lord?
For tomorrow.
New motion for inclusion. It was
No inclusion right now.
My lord, may I have your lordship's kind leave to mention a matter, my lord? Of Justice Amrita Sinha's determination, my lord.
Top 5 matters. Take this one. Well, yes. Tomorrow is my original site matters. And this will come up day after tomorrow, sir. Let the financial bit be opened. We'll see that. If you
My lord,
qualify.
in respect,
Today I can't take it, sir. No, Friday. Will.
my lord, with respect to original side matters,
See that.
Not
If you're
inclusion.
eligible,
The old lady, my lord. This local unity, my lord, they are constructing the wall, my lord.
Friday.
Put up the house, my lord. See, you know,
sir, whosoever is building the wall will get demolished. Wait for your turn. No urgency. Yes.
my lord, may I have your lordship's kind leave to mention a matter?
Application.
Just a minute, sir.
My lord, I'm sorry, my lord.
And if you want priority, come here to the court.
My lord, I'm so sorry, my lord. I
It's
tender
fine.
my appeal.
Inclusion for application.
Yes, Mr. Ban.
upon extended affidavit for that direction of the park and the direction of the only the common direction for affidavits so that that's all the matter. Structure has been put up in front of the window.
Structure will go, Mr. Banerjee. What is the big deal?
In front of the window, somebody can now.
Oh, that's all right, Mr. Banerjee. No urgency. No urgency. It will come up. It will come up, Mr. Ban. It will come up, Mr. Included. Put it in the list. Yes. Very good. It will get implemented. Sir, wait. We will upgrade from next week. We will see that. Let me finish up some matters.
Inclusion for application.
Yes.
Inclusion for application.
Sir, wait for inclusion. From next week, you come for the inclusion.
Additional floors have been constructed without obtaining sanction.
Very good, sir. It will get demolished. Don't worry. Yes.
Private restaurant making construction by demolition the.
Very nice, sir.
The petitioner, my lord.
Let it come up.
May I be permitted, madam?
Yes.
Well, sir, tender
Just
matter,
a minute.
well, tender matter I have been blacklisted. This honorable court quashed the order and directed the municipal authority to pass order within 7 days. Within 7 days, they did not pass order, subsequently blacklisted. Now, my lord, tender has been published, 25th April is the date. My lord, from when, my lord, the new, my lord, tender will come into effect. That being the situation today, that being the situation. Well, that is in the list.
Put it in the list. Okay.
Deep level.
Yes. 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 No urgency. Yes.
May I permit to mention?
Yes.
May I permit to mention?
Sir. No urgency. Go and mention wherever you want. Yes.
Slaughterhouse, slaughterhouse, coming, the local people have referred this application. It will be finally fixed.
I'm sorry, I didn't follow you.
This is a writ application against running of a illegal slaughterhouse in
When is the slaughterhouse running, sir? Since when is the slaughterhouse running?
2-3 years.
No urgency.
May I
Yes.
permit to mention? For non-prosecution.
Just a minute. Yes.
For non-prosecution.
Non-prosecution. What dismissed?
Dismiss.
Restoration application.
I have dismissed the matter.
No urgency. Yes.
tender matter, because I am going blacklisted, Lord.
When is the tender opening?
Tender was opened, Lord, it is my fault. I did not practically quoted double rate. I am guided by Lord. The matter is covered by 2 honorable Supreme Court decisions. Two decisions, Lord, where the stated, Lord, that if the rate is so high, I have a liberty to pray, Lord, to cancel the bid, take back my EMD. That prayer has not been considered, and now they are proceeding to not blacklist me and forbid my EMD.
Let them proceed.
My lord, matter my lord,
Yes.
may we permitted to mention, my lord, the matter pertaining to Justice Amrita Sinha, my lord, item number 928. My lord, I am a participating tender and I am working in the, but without any notice, when my tender is being cancelled and a blacklisted employee, my lord, a blacklisted tender is going to be awarded the tender, my lord.
Going to be awarded.
No, no,
we will-
by the end of this, my lord, the matter of speak, my lord, the matter.
The tender has been floated.
Yes, my lord, the tender is
Is the last date for submission of the bid. 30th of this month.
yes, my lord. Before that, any date.
Take it.
My lord, matter has been dismissed for default because of the fault of the advocate, my lord. But it's Justice Sinha's matter, Sinha's determination.
Before Justice Sinha, after second, sir. Dismiss in default, go.
My lord, may I be permitted to mention?
Go before the honorable.
I am permitted to mention item number 68, my lord. Yesterday it was 62. It is that matter where bank is about to take my residential home, my lord. Kindly show some preference and take up at 2 p.m., my lord. Otherwise, my position will be dispossessed. It was yesterday mentioned on the after date also mentioned, your lordship.
We'll have it on Friday.
Kindly 2 p.m. lordship.
Friday, not today.
My lord, upon notice,
Friday top, lordship. Kindly fix at
Friday, take it on Friday.
my lord, upon notice to the other side, my lord, I pray for the upgradation, my lord.
Upgradations are not right now. Yes.
My lord, there is urgency,
We will have it from next week onwards, not right now.
my lord, there is urgency, my lord, for
Rejected.
my lord,
I heard it, rejected, no upgradation. I'm asking you next week.
My lord, upon notice, I am mentioning matter. On 3rd of December, an order has been passed by Honorable Justice Kaushik Chanda, asked the Srirampur municipality to deposit 1 lakh rupees and also the same direction upon my client. My client is a respond number 5. He is a senior citizen, my lord. I am praying for only inclusion in the list and can application has been filed here.
Sir, inclusion next week onwards, not. Yes. Upgradation, don't mention right. Don't mention right now.
My lord, with my lord's permission, can I mention one matter? My lord, despite of NGT order, my lord, the private responder continuing the work, my lord, in a residential flat, my
Very
lord.
good. Let him continue. It will get demolished if it's.
No, my lord, it's a municipality matter, my lord.
That's what I'm saying. Municipality
No,
will
unauthorized,
demolish it.
not unauthorized construction, my lord. It is a municipality matter where, my lord, a private respondent is running a factory inside a residential flat, my lord.
It will get closed, sir. No urgency. Yes.
Good.
Yes.
Justice Amrita Sinha, your lordship, is a matter.
Speak in the mic.
My lord, this is a matter of victim compensation, your lordship. I'm mentioning from the
Matter of what is
victim
it?
compensation.
Victim compensation. It can wait, madam. Go on.
I have been selected as L1 candidate. Previously, I was debarred by another company in participating of their tender. In this tender, subsequently, I have been selected as L1. My work will be commenced from 1st of May. Because of the debarment which was passed by another authority restricting me to participate in their future tender, the present authority is obstructing me in participating, continuing with the work order.
So the debarment in the other tender.
That company only, the DVC debarred from participating in their future tender.
So generally, the tender condition will always have a clause that if you are debarred in any of the tenders anywhere, that will act as a deterrent to participate in this one also.
But this clause was not there. I was debarred by another company from participating in their future tender, not to other.
Take it, we'll see that.
May I be permitted to mention?
Yes.
No.
We'll have it later, madam.
May I
Next.
Blacklisting order against me, your lordship, on a similar footing. This is due to expire on 28th of May, your lordship.
What is expiring?
The blacklisting order.
Blacklisting?
But I
I'm not in. Blacklisting, I'm not getting it.
The blacklisting.
That's all right. Wait.
May I be permitted?
Wait for your turn, sir. Blacklisting, I'm not getting it. Yes.
Arbitrarily, property tax has been parted upon.
Very good.
Now the claims authorities have initiated recovery.
Go before the municipal valuation. What is
Demolition notice was-
Yes.
My lord.
Sorry.
This is the pertains to Justice Omrita.
Yes.
In both the cases, the petitioner, they are reaching the threshold age and they could not avail the assistant reproductive technology. That is to be offered by respondent number 4.
No urgency. Yes.
Be permitted to
Permitted to mention.
upgradation of
Yes.
matter.
Yes, madam.
This case is appellate side, item number 1713 in the monthly list of April. This case has been filed under the name of wrong petitioner. So please allow us to withdraw the matter and file a fresh one.
Take it.
Namaste, my lord. May
Just
Namaste, my lord. I am standing in person, WPA 20896 of 2024, in the determination of the Honorable Justice Amrita Sinha. She has given the order on 8/4/25 to repair my flat, to repair the rooftop of my flat. But the administrator has not started, and she has directed to complete it by the 13th May. But she has not, administrator has not started yet. Rather, he is campaigning against the order. Kindly given hearing order. This is a,
you go before the regular bench.
yeah,
Go before the regular bench on 2nd of May.
May I permit?
Thank you.
Or may I permit to mention the application for consideration and representation of the installation of a lift in the 4th floor. For the cancer patient are there, but the senior citizen are staying in the 4th floor. But I filed the read appearing in the monthly list, 6-7 months is gone. Only the corporation need to consider my representation whether it is possible for installation lift or not.
Next week. Mention it next week.
May I have your leave, lordship, to mention a matter for upgradation, your lordship? This is a
Upgradation next week onwards.
unauthorized construction, your lordship.
May be permitted.
Unauthorized construction, nothing.
No, there are.
My lord,
almost
this
floors,
matter,
Nothing.
8 floors.
Yes.
my lord, this matter pertains to encroachment of a private pathway whereupon I exercise my easementary right.
Very good.
This is a pre-listed matter. It is, my lord, in a monthly list, item number 2158. But recently what happened, my lord,
Yes.
they have entirely stopped my ingress and egress in my property since 14th of April.
Next week onwards, mention this.
My lord,
Yes.
demolition
My lord,
notice
my
was
lord.
issued, my lord. I have filed a statutory appeal, my lord. Appeal is pending, my lord. Another notice has been issued for demolition of the, my lord, the premises.
Very good. If the
My lord,
premises,
My
nothing.
lord, matter is
Nothing, sir.
May I be
Yes.
permitted to mention a original side matter for extension of interim? This is my,
When is it?
it's expiring on 38th, but that is next Wednesday.
Yes.
And my lord takes up original side matters only on Thursday. Upon
My lord, may I be permitted to
Yes.
mention a matter for hearing on Monday, my lord? There is a certain urgency. I'm praying for challenging the cancellation of my excise license, my lord. Due to cancellation of that license, a criminal proceeding has been initiated against
Madam,
me.
when was the license cancelled?
My lord, in 2020.
All right.
My lord,
No urgency.
my lord, the interim order is
No
expiring, my lord, in the first
When-
week of May, my lord.
Very good.
So, my lord,
Mention it before the roster.
my lord, it will expire by then, my lord.
Roster bench, first week, 2nd May
My lord,
onwards.
my lord, before that, first week of May, my lord.
No point, madam.
My lord, 28th,
No, madam.
Monday.
No, not at all. Yes.
My all losses are allowed to upgrade. I know, man. Municipal matter, but my
I will
English
allow
outgrade is stop.
upgradation. You wait for some time.
But
Let me
English, my
organize my
English,
board.
I pardon. But English, my English outgrade is stop, man. Unauthorized construction.
Sir,
Municipal declared is
from
unauthorized.
next week onwards, I will organize my board. That's why I'm not allowing upgradation. It's not that I don't want to hear those matters. Let me organize my board. Next week.
My lord, may I
onwards.
be permitted to mention one matter?
Lordship, raise the matter hearing before the Honorable Justice Amrita Sinha, my lord. Thing is that, my lord, what is come before your lordship, what is the reason? Urgency is that, my lord, petitioner is the by profession chartered accountant. He is
Very
the
good.
insolvency professional also. Has
Very
to attend the meeting in the Singapore educational program, my lord. Come to the end of this month, my lord.
Very good.
I have attached the certificate of registration. I have attached the, my lord, that is the International Association of Restructuring and Insolvency Bankruptcy Professional. My lord, meeting to be done, my lord, end of this month. My lord, any day, my lord, kindly give me one chance, my lord, to because there is a restriction imposed by the Ministry of Corporate Affairs. I could not travel the approach. That's why I have
Let that You will get more invites, sir. All right. You are a very qualified person. More invites will come to you.
Lordship,
No urgency. Yes.
traveling has
You will
been
get
restricted.
many more invites. Yes.
My lord, may I be permitted to mention?
Not at all.
It is professional.
Professional, you'll get many more professional. You're very qualified.
Lordship,
If the ministry has
kindly
imposed
give me
certain
one
conditions,
chance, my lord.
not at all. It will come
I
before
have to attend the
roster bench, sir. Nothing doing.
My lord,
Yes.
may I be permitted to mention one item from my lord Justice Amrita Sinha's bench, my lord? What happened, my lord? A SARFAESI application was we think, my lord, the landlord, my lord, we are pre-mortgage tenants, my lord. Now, my lord, the bank is coming to grab the property, my lord. We are there from 1970s, my lord. Now they have come yesterday. Now they have threatened us to come tomorrow with police, my lord.
Let them come. Nothing. Yes.
Lord, may I be permitted?
Cancer patient, my lord. Petitioner is a cancer patient.
What do you want?
Lord, inclusion in the list, my lord.
Next week onwards, I'll include matters. Just wait.
My lord, kindly give some preference because cancer patient.
Next week, mention it.
Lord,
Yes.
may I be permitted to mention?
Sir, next week. Next week, sir.
Kindly hear me for a moment. My life is in danger.
If your life is in danger, go to the cops. Go to the police station.
Yes, we cannot do anything because things.
Even I can do nothing. Yes, next. Next.
My lord,
Next.
my lord,
Sir.
One judge, if the lordship not satisfied to my submission, because of the fact that any time any untoward incident can take place due to illegal construction of the building. Now, I make the representation to the municipal authority a series of occasions, but no reply. There is gross inaction of the authority.
Good.
Kindly protect me.
Very good.
They need jurisdiction. They
Very
are
good.
violating the gross rules of the natural justice.
Very good.
In that event, lordship,
Very good.
kindly give the protection.
Third, rejected. Yes.
my lord, may I be permitted? My lord, just now, Mr. Rahul Komar mentioned on the matter, my lord. 152 days list, my lord. So demolition at Friday at 10:30 am. If your lordship kindly fix up the time today, my lord, because tomorrow your lordship will take an urgent matter, my lord. Because they have given.
Demolition, unauthorized construction. If the law permits, let them do it. If you're coming at the last minute, I can do
Kindly fix up a time today, my lord. Otherwise, that.
do nothing for you.
My lord, without notice
If
they have
you are
done,
coming
my lord,
at the
without
last
giving,
minute, I can do
my lord,
nothing.
without giving any notice, the hearing has
I
done.
can see it. Friday, take it for Friday.
My lord, without giving notice, they have done this, my lord.
Sorry, sir, you should have come earlier.
My lord, when they have given notice, I have filed this petition, my lord, without giving any hearing, my lord. My only prayer is, my lord, let the hearing be done, and then, my lord, kindly fix a time today, my lord. Kindly.
Unauthorized construction, demolition.
It is not unauthorized, my lord. From 1974, that building was over there, my lord. From 1974, my
You
lord.
have a sanction plan?
My lord, because.
You have a sanction plan?
My lord, I am the tenant coming over here because.
Tenant?
Yes, my lord.
Nothing do.
No, my lord, kindly appreciate, my lord,
Nothing do. Sorry, rejected.
My lord, kindly appreciate, my lord, kindly appreciate, my lord. That is not the fact, my lord.
Nothing doing.
My lord, kindly hear me. My lord, kindly hear me. Kindly fix at 10:30 am tomorrow, Friday, my lord.
Nothing doing, sir.
Friday.
Nothing doing.
My lord, Friday at 10:30 am, kindly, my lord.
Pending
My lord, kindly Friday at 10:30 am, my lord, kindly, my lord.
Sir,
Because, my lord,
it will come in due course.
my lord, municipal had given,
come
my lord, kindly appreciate, my lord, municipal.
Tenant, nothing doing.
My lord, it's not that, my lord, it has been leasehold, has been done, my lord. Municipal is knowing all the fact, my lord. They've taken tax from me, my lord. They were given 10 license, my lord. Kindly, my lord.
Go to the civil court.
My lord, kindly fix it at 10:30 am
Sorry,
Friday,
sir.
my lord, at top of the list, my lord. My lord, kindly, my lord, kindly.
No, sir. Nothing.
Matter of
My lord, kindly, my lord, fix it
Don't
at
you
10:30 am Friday, my lord. Kindly, my lord. I pray before lordship, my lord. Kindly.
I'm not hearing it. Yes.
Matter of Honorable Justice Amrita Sinha Lordship, the petitioner is restrained from participating in the tender. The tender will Lordship start from 28th April.
When is the last date of submission of the bid?
E-auction, Lordship, date of opening 14/5 and e-auction start from 8/28.
No urgency. 14/5, no urgency. Yes.
Lordship, that will open.
Sir, no urgency. Yes.
Petitioners is the owner of the property, but KMC, my lord, included some other person, third party's name, my lord. And now, my lord, without any opportunity given hearing,
Mutation matter.
mutation.
No urgency. Yes.
But my lord, the third party matter, if you
let it
lordship
come up,
can
sir. Let it come up.
But it is, my lord,
If the third party has been illegally
included,
get cancelled.
but my lord,
also.
now they transfer to third party interest. That is my.
Will get cancelled, sir. Don't worry. Yes.
Yes, my lord. Item number, my lord.
Yes,
Monthly
sir.
list, you lordship.
Next week, mention it. We'll upgrade it.
Matter of Honorable Justice Amrita Sinha's bench, my bank account has been liened for 1,40,000 for illegally has been liened by SBI. We have reached the police station also. The police station has said there is no FIR, nothing is there.
Very good.
My
Nothing is
money is stuck and I
Nothing
cannot
is there, sir. Nothing
continue
is
my
there. Yes.
daily expenses.
Nothing is there. Yes. Upgradation next week.
My lord, I have permission to mention, my lord, three identical matters. In fact, my lord, the coordinate bench of this honorable court, my lord, passed similar orders, my lord, regarding, my lord, engagement in the post of Shoika. My lord, though the vacancies are there, my lord.
No urgency.
My lord, similar orders have been passed, my lord.
My lord, petitioner was disposed
Sir,
of
they are
the
going to
Pinias
fill up the vacancy, my lord.
4th October 2024, my lord.
Should I
Sorry?
mention next week,
No.
my lord? Next week.
Next week, please.
My lord, kindly permit or allow me, my lord.
What is it?
My lord, petitioner was dispossessed from the premises on 4th October 2024, my lord. My lord, the sudden and unlawful evictions needs immediate attention, my lord. Multiple complaint of the KMC authorities. No actions has been taken, my lord.
Nothing is there. Yes.
My lord, I'm
Fine.
trying for inclusion in the daily list, my lord.
Inclusion next week
My
onwards.
lord, one civilian person who has no authority to construct in the ex-serviceman cooperative society area is he is constructing in this area, my lord. And my lord,
Anything which is
honorable-
getting constructed illegally will come down, sir.
My
Law
lord-
will take its own course. It will get demolished.
My lord,
Next-
my lord,
may I be
honorable-
permitted-
No
honorable
urgency.
division bench has passed an order.
It will, division
for
bench
verification of
order
the
will
list
be,
and-
the division bench order will be complied with. Any illegality per se regarding the order, non-compliance of the order, the law will take its own.
My lord, may I be permitted to mention a matter?
My
This
lord,
is a,
if
Sir.
this matter is not here, my lord, another board will come and they will indulge the wrongdoer person, my lord. At present,
Sir.
my lord, there is appointed one special officer.
No urgency right now.
my lord, this is a new motion matter pending since 2023. The matter has not been taken up. It is
Next week you mentioned.
This matter was filed in year 21. Since that, it has not been heard.
Next week.
My lord, this is my lord an urgent determination from my lord Justice Amrita Sinha. The difficulty is, my lord, on 25th, my lord, the bank is slated to take possession after, my lord, the DM's order. Now, my lord, I can, my lord, show, my lord, from the records that fraud was played, my lord, against, my lord, the petitioner, and, my lord, with respect to fraud, my lord, I am, my lord, squarely covered, my lord, by a judgment of the division, means that portion, my lord, cannot be, my lord, adjudicated by the DRT. My lord, day after tomorrow, my lord, the bank is, my lord, taking possession, my lord.
Is there a notice from the bank?
Yes, yes, from the DM's office, my lord. Yes, that is there. My lord, kindly sees, my lord, this. This order, my lord. My lord, the order is annexed. There to my lord. My lord, the next page, my lord, the order starts.
No urgency.
My lord, kindly considers, my lord.
No urgency. Next.
Wait.
Call out the list.
Lordship deliberated two matters. One matter, my lord, happening people, my lord, is.
My lord, kindly to mention.
Then I have fixed deposit but not allowing to withdraw the money. Just seeking permission from the bank that my money should be allowed to withdraw.
Sir, you mentioned before the roster bench. These are only urgent matters. Your money is there for a long time. You can mention before Justice.
Another matter, my lord, I have got some landed property.
Very good.
There are, my lord, 6-story building here. Some portion I have already sold by way of making construction of the flats through promoter, and I have some portion under. Now I am, due to financial crisis, I am proposing to sell some other portion. Now all of a sudden, it is seen that the bank, the property is in the Rose Valley company, and it has been asked by the register not to sell the property.
Very good. Very good, sir. What can I do?
My lord, because
Those matters, you know, are pending before the division bench. Those are orders passed by the division bench. If the Rose Valley, sir, property dispute, I'm not here to solve your property dispute. All right. I'm not here to solve your property dispute. If the property has been put in the category of Rose value.
But I have the absolute recorded order.
Very good, sir.
But
Is there any unauthorized construction there?
no.
All right, sir. No urgency.
No.
Yes. Next, call out the list.
My lord, may I have your lordship's kind leave to mention now, my lord, urgent determination matter of Honorable Justice Amrita Sinha.
Yes,
My
Mr.
lord, the interim order is expiring on 30th of April, my lord. Tomorrow, it's an original side matter, so I was beseeching your lordship if you can be placed tomorrow in the list, in your lordship's original side list, my lord.
All right.
My lord, I'm giving the slip to your lordship's officer. I'm so deeply obliged.
Give the slip.
My lord.
Where is the slip, Mr. Ghosh?
My lord, my solicitors, my lord, would be there, my lord.
Nobody is here.
My lord,
Problem?
I'll give the slip, my lord.
Solicitors, nobody is here.
My lord, solicitors should be there, my lord. I'll give your lordship's officers the slip, my lord. It's an original side matter with the order of Honorable Justice Amrita Sinha, my lord. I'm so, my lord, embarrassed. So, my lord, embarrassed that they are not there, my lord. I'll immediately, my lord, send for them.
You are a big lawyer appearing online. The solicitor is bigger than you, not coming to the court. Only the court is here, waiting for all of you to come.
My lord, I'm so deeply, I cannot have words to express, my lord, how sorry I am. They should have been there. My lord, I shall give the slip to immediately, my lord, within 5 minutes to your lordship's officers, my lord.
All right.
My lord, item number 1, my lord. My lord, item number 1, my lord, I am appearing for the petitioner, my lord. My lord, I am praying for not today, my lord. My lord, due to the learned advocate briefed in this matter, miss, my lord, has undergone eye surgery, my lord, still not recovered yet, my lord. My lord, kindly see the order dated 9th.
Subject to what Millard feels, Millard. Perhaps, Millard, there is page 67, Millard, which is a representation before the commissioner alleging illegal construction, Millard. We are already in the view of virtue of taking steps under 266, Millard. Millard will kindly direct us to consider this application at page 67, Millard. Perhaps that will serve the purpose of the writ petition, Millard.
Yes.
Yes, my lord.
The present writ petition has been preferred, seeking demolition of illegal and unauthorized construction raised over the land of the petitioner, which is jail number 17, RE.SA number 349, Tawzi number 228/229, RS Dag number 349, pertaining to RS Khetan number 405 under Bidhan Nagar Municipal Corporation, Ward number 18. Ward number 18, Police Station, Rajarhat. Police Station, Bagya Guti. North 24 Parganas. Full stop. It is the case of the petitioner that he is the absolute owner of the land in question, with an intention to develop his land. He had entered into a development agreement dated 7/10/2020 with the private respondents, full stop. However, the private respondents, without obtaining the necessary permission from the municipal corporation, started raising unauthorized construction of a multi-story building over the said land, full stop. The petitioner has preferred a representation dated 11/12/2024 before the respondent authority, but no action has been taken by the concerned authority, full stop. Learned counsel for the respondent authority, Mr. Nag, appears and states that they are ready and willing to decide petitioner's representation dated 11/12/2024, full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner, full stop. In view of such statement, this court directs the respondent corporation to decide petitioner's representation dated 11/12/2024 within a period of, Mr. Nag.
Lord,
within a period of
12 weeks, my lord.
within a period of 12 weeks from the date of communication of this order, after affording an opportunity of person hearing to the petitioner as well as the other private respondents. Full stop. By way of a speaking. With the above direction, the present writ petition is disposed. मुझे एक लाइन ऐड
Obliged.
नो एफिडेविट
I am for the municipality. I am for the petition. Lord, if it been opposition, Lord, has been filed.
Last
By the
petition, my lord,
municipality.
used to direct us to there between opposition. We have prepared and staff from the petition.
Lord, the opposition, Lord, has not been filed by the state.
That's all right. They are the necessary. Who's the necessary party?
The necessary party is the state.
State. Who appears for the state?
Sujata Mukherjee, my lord, is appearing for the state.
She is not here.
He told me, my lord, he will file, my lord, he will seek extension of time, my lord. Just before few minutes, my lord, she met me. My lord, your lordship kindly take up, my lord, next Wednesday, my lord. In the meantime, I will give reply also to this opposition.
Learned counsel for the respondent municipality has filed his affidavit in opposition. Counsel for the petitioner seeks 2 weeks time to file 1 week time to file his exception to the same. Full stop. Learned counsel for the state is not present. She is directed to file her affidavit in opposition within a period of further within a period of 1 week. Full stop. Reply to the same, if any, within 1 week thereafter. List after 2 weeks. Affidavit in opposition is taken on record. Taken on record.
No, another same heading, Lord.
7th May. Same heading.
Good.
Item number 3.
Well, item number 3, I beg to appear on behalf of the petitioner, my lord.
For the state.
My lord, I have served to the Mahestala municipality, my lord. On the last occasion, I have submitted my affidavit of service, my lord. This is matter relating to illegal construction, my lord, by filling a pond, which is adjacent to my land also. Even the private respondent, my lord, they have encroached on my land also. And without leaving any passage, my lord, illegally constructed on a Doba land, my lord, which is pond, my lord.
Yes.
And my lord, my representation, page 19, my lord, I have also submitted, my lord, translated copy.
Page
19, my lord. Kindly pass a direction to consider my representation by the concerned authorities of the municipality.
Yes, sir. Who appears for the municipality? You?
I'm for the state.
Who's appearing for the municipality?
My lord, I have served through speed post, my lord, but
Respondent number 2 is the authority. Lord.
Which municipality is this?
Mahestala municipality, my lord, South 24 Parganas.
Mahestala municipality.
লিস্টটা এখানে সামনে নিয়ে বসে নাকি
Please find out who's the lawyer who appears for Mahestala. I have a list, but Mahestala is not here.
My lord, it's very tough to find out, my lord, who is appearing because I have already served, my lord. Your lordship can pass a direction to consider my representation, my lord, by the authorities concerned. Only to consider my representation, my lord. Thereafter,
Just take down. The petitioner has the present writ petition has been filed alleging unauthorized construction at what is the address?
My lord, it is
At
Maheshtal,
LR.
South 24 Parganas.
LR plot numbers 442/942, Khaitan number 3149 and 3148, jail number 06, Moza, Navapara, PS, Maheshtala, District, South 24 Parganas. At the instance of respond number 7 and 8. Despite service, none appears for the municipality. Full stop. Learned counsel for the petitioner states that he has made a representation. What is the date of the representation?
My lord,
Representation
my lord,
dated
22nd November 2020.
2024. Yes. Who? You serve this copy. Not served. Not today. Not today.
Day after tomorrow, my lord, if I
Friday.
do not have contact of Mr. Raghunath Chakraborty, so I have to find out. my lord,
Monday we'll have it.
Monday.
Great.
And just make a note in that Raghunath Chakraborty, Maheshtala. You give the number also, sir.
Item number 4.
Lordship, in item number 4, Lordship, my counsel is indisposed. Kindly fix any day on the next week so that.
Not today. Next week.
Next.
Monday. Not today. Not today. Next week. Monday. Item number 5.
Item number 5, which appears on behalf of petitioner, my lord. The petitioner complains of an unauthorized construction, my lord. Last occasion, responded municipality 6 times to inspect the spot and file report. My lord.
Yes.
Yes, my lord. This is the report my lord will find as I submitted on earlier occasion, my lord, that is a case of repair.
The case of?
Case of repair in respect of old dilapidated building. Some photographs I have annexed, my lord, after repair and before repair.
And who are you?
I'm the co-sharer of the property, my lord.
Co-sharer of the
Co-sharer of the property. My lord, kindly see the page 32 of writ petition, my lord. A leave to file on opposition, my lord. Report. Report at a copy.
Page?
Page 32, my lord. Photographs, the nature of construction. 32 and onwards.
But due respect, madam, submitting those photographs doesn't reflect the actual picture. Nothing could be, my lord, ascertained. Your lordship will kindly see the colored photographs I have handed over.
Yes.
The last pages are the before repair, my lord.
The present writ petition had been filed alleging unauthorized construction at 58 Rabindra Sarani, PS Ranaghat, District Nadia, at the instance of private respondent number 6 and 8. Learned counsel for the petitioner is the co-sharer in the said property. The dispute between the parties are private in nature. Full stop. Though, since the allegation of unauthorized construction was raised, this court had directed the respondent Ranaghat municipality to conduct an inspection and file a report. Council for the Ranaghat municipality has conducted an inspection and has filed a report. The same is taken on record. The record reveals that there is no unauthorized construction which is being carried out. The nature of construction which is being carried out is in the form of repairs, and no illegal construction is being done on the said property. In view of the said report, this court does not wish to pass any further order since this dispute between the parties are civil in nature and the allegation of unauthorized construction is found to be without any merit. The present writ petition is dismissed. Report, both the reports are, report filed by the state is also taken on record.
Yes. Can I get a report, copy of report?
Give a copy of the report.
But I shall give him. দেখতে দাও দেখতে দাও চেক করে চেক করে নিয়ে দেখো তোমার মুখে তো হাজির ছিল হিয়ারিং কেন এসব বলছো
Item number 6.
I am but the petitioner, my lord. Corporation supposed to submit the report.
Howrah Corporation, my lord.
Hey.
But I'm placing the prayer 50, prayer A of the petition, my lord, page 15, my lord. A read
মহেশতলা municipality.
page 15. Prayer A. A writ
Yes.
of another nature of mandamus commanding so and so to immediately implement the self demolition notice 22nd January 24 as earlier directed by the honorable court in so and so matter. But I am ready with the report.
Yes.
And we have already done the demolition matter. Demolition work was done.
You must be aware
Reported copy
demolition has taken place.
and placing the report also.
When was the demolition action taken, sir?
My lord,
When was the demolition action taken?
demolition has been taken on.
Your report is neither here nor there. Have you read it, Mr.
As
Banerjee?
per their report, my lord,
Have you read your report, Mr. Banerjee?
My lord,
Have you read your report?
I have
Very,
the demolition program has been scheduled on 21/8/2024. So this was the demolition program given to the police.
Mr. Banerjee,
Police was
you are supposed to give the current report. What is the report today?
My lord,
What happened to the demolition? It has already been
demolition
carried out.
has been done.
as
have
per
carried
my
out the
instruction,
demolition on that date.
the building standing as intact as was previously.
File your exception to the
I-
report.
I
Mr.
shall
Banerjee, this is not a right
If
report.
that it is so, I will tell them that it has not been
This
completed.
is, Mr. Banerjee, you are a seasoned lawyer. Look at what report they have filed. They have just given you the old report.
They would have to complete the demolition.
They have to complete them, should have conducted an inspection and then filed a report. After passing of this order, you are supposed to give a new report. After conducting an inspection, your report is still the old report. There's nothing new in this report.
I will say them to inspect and then fix a demolition date. Thereafter come with the report. I'm sorry, my lord, I'm praying apology, my lord.
This is what is supposed to be done, Mr. Banerjee. They can't take you for a ride. They are taking you for a ride, Mr. Banerjee. How can you not see this?
My lord. Give me some time, I will.
Mr. Banerjee seeks further time of 2 weeks to file his report. Don't file this.
I am not filing that.
Let this matter appear after 2.
I'll come with an affidavit also.
Affidavit in the form of
No, the exception হবে না. I'm coming with an affidavit with them.
affidavit in the
After
form
making
of
an,
report.
after conducting an inspection. My lord, then when the date is fixed, then next.
You tell me when do you want?
2 weeks, my lord.
2 weeks, 3 weeks, whatever you want, so that.
I will
Please
come
give-
with the inspection report along with the report in the form of affidavit.
Report in the form of affidavit. Within 3 weeks, 4 weeks.
3 weeks, 3 weeks.
Because demolition takes time.
Demolition will take some time, but I will come with a report regarding what advanced stage has been done, everything has been done, that I will come with a report.
I'll give you 4 weeks.
4 weeks. 4 weeks.
Just take down the petitioner in the present writ petition is aggrieved by the inaction of the respondent municipality in not carrying out the demolition action qua premises number demolition action qua premises number 21/3 of the B, comma Umesh Banerjee Road, comma PS Shivpur district
ভাঙার
Hapra,
তো ছিল, ভেঙে তো ছেই।
despite passing of a self demolition order dated 20. What is the date of the self demolition order?
7th of November
7th of
2023.
November 2023. Full stop. It is the case of the petitioner that she is the co-owner of the property, comma having co-owner of the property.
My lord, after 7th of December,
noticed.
my lord, I should be stand corrected. In my writ petition, 22nd January 2024, one subsequent self-demolition order was passed.
22nd January ka kar dena. 7th November matlab sir 22nd January 2024. She is the owner of the property and had noticed massive unauthorized construction happening. She is the owner of the she is the neighbor.
I am the neighbor.
She is the neighbor, sorry, not co-owner. She is the neighbor.
Adjacent
of the
neighbor.
adjacent property and had noticed unauthorized construction being carried out by the respondents in the above mentioned property. Full stop.
4 weeks মানে কত হচ্ছে 4 weeks?
Full stop. Thereafter, she had filed 2 writ petitions, WPA number 21601 and 8497/2024.
So,
full stop. After the direction passed by the after the filing of the writ petition, the municipality had passed a self-demolition order dated 22/1/2024. Full stop. However, till date, the unauthorized construction is intact and no action has been taken by the respondent municipal authority. Full stop. Mr. Sandeepan Banerjee, appearing for the municipal corporation,
to come with the completion of demolition.
States that he shall file a compliance report in the form of an affidavit after carrying out the necessary demolition action within a period of 4 weeks. List after 4 weeks.
Section
21st May.
21601 of 23 and 8497 of 24.
Much appreciated.
I will come with a compliance report and in a form of affidavit.
Yes.
But 2 floors are there. It will take some time. In any manner, I will come. Majority of the portion will be demolished. That I know.
You can file periodically.
I will.
Good. Yes.
Number 7.
Lordship, item 7 to 15, these are identical matters. In all these matters, I appear for the petitioner. Your Lordship, this is with regard to employees of Hooghly Chunsura municipality who were originally employed as coolies and now have been renamed as conservancy workers. Lordship, the Hooghly municipality has submitted an opposition totally in our favor that we were permanent employees and we were entitled to our retiral benefits. What requires to be done here, Lordship, is that Director of Local Bodies has neither filed an affidavit nor has come forward
We had the municipality like item number 2.
We have not used a reply because this is totally in our favor, admitting the fact that we are permanent employees. We are entitled to retiral benefits. Therefore, but Lordship, would you kindly come to page 7 of their opposition? N.
Yes.
Lordship kindly takes up paragraph N. It's pertinent to mention here that out of a total 148 employees, 8 retired persons standing on the same footing as the present petitioners moved separate writ applications. Lordship, those applications were also moved by us. While adjudicating those writ petition, Lordship, a coordinate bench has passed orders. Lordship, I have the order before me. Passed on different dates, certain information and documents were directed to be furnished by the municipality, which were accordingly done. After considering the whole aspect, out of 8 petitioners, approval of redesignation of conservancy worker was allowed by the director in respect of 6 petitioners, issuing memo dated 21/6/2024. On the basis of such approval, this Honorable Court, by passing different orders in those previous litigations, directed respondents to release the pensionary benefits within a certain period. Lordship, these persons have got provisional pension, not full pension. But what I was praying before your Lordship, an order is required to be passed on the director of local bodies to approve these cases, Lordship. The service books, Lordship, I have the orders, Lordship.
Ma'am, who appears for the director local bodies here?
They will not appear, Lordship.
Will not appear.
Lordship, I do not know. They have not neither filed an affidavit nor have they come.
You have to appear. Who appears for the state?
I am appearing for the state, my.
The state appears for the director local bodies.
My lord, I have missed, my lord. Last appearance, my lord, I have missed.
A junior had appeared on the last occasion. A junior had appeared on behalf of the state.
What is your name?
No, my lord, state has not appeared, my lord. Last occasion, my lord, when you lord order passed, my lord, 26th March.
Yes.
2020.
Sir, you speak in the mic. Speak in the mic. Yes.
We did not appear, my lord, before your lordship on last occasion, my lord, 26th March. My lord, and I have not, my lord, copy of the opposition.
You don't need copy of the opposition.
My lord, kindly give me a time, my lord, short time, my lord. I will take, my lord, instruction.
What is your name?
My junior.
Your junior had appeared last time?
My lord, she is also not present, my lord. My lord, kindly give me.
Kind of argument.
Kindly give me, my lord, 7 days time, my lord. I will take instructions from the local bodies.
You file your affidavit. Learned counsel for the state, Mr.
Pradeep Kumar Mandal.
Mr. Pradeep Kumar Mandal appears and states that the junior who had appeared on his behalf did not communicate the previous order passed by this court on 26/3/2025.
The last occasion also, my lord, there is no direction, my lord. Kindly see upon the local
further time of 1 week to file his affidavit in opposition. Full stop. Reply to the same, if any, within 1 week thereafter. You want to file your reply to this?
Lordship, this I do not need to file a reply. It's supporting my case. Lordship, may I make one humble prayer?
the copy of the opposition.
You don't need a copy of the opposition. You only need copy of the writ petition.
Lordship, my humble prayer before your Lordship is that the municipality is ready to send the service books of the petitioners to the director of local bodies, but they say unless an order is passed, they will not accept the same.
They will accept the same, madam. You send it.
Lordship, that is what my learned friend has been saying.
And you send it by dark, they will accept it. You're a government department. What are you saying?
That is
no difficulty. We are not standing.
You send it by dark. If they refuse it, you come back to the court.
And my lord, from the writ petition, my lord.
Behave like private citizens.
Lordship.
And you go to office, the Babu will tell you, go away from here, and you will go away.
That's exactly what I was telling my learned.
Since 2009,
how can anybody refuse you?
2019, we are sending one after another letter requesting that the director of local bodies, please you change the designation. Only difficulty is the change of designation. They are not acting up.
They'll
2019.
They will.
My lord, kindly see page page 34.
Sir, you don't even show
Municipality
anything.
rejected by not filing the application for proper form. Municipality rejected.
Not municipality, your department.
No.
Due to mismatch
Fifth-
of the designation, all the
Yes.
petition files were rejected by the government.
Sir, when you don't know something,
by
then wait for your turn. Counsel,
My lord.
when you make a statement, you should know the facts.
Kali see.
What সি বলছে সাহস কত?
List after 2 weeks.
May I pray this is a peremptory order on the director of local bodies to file an affidavit because this is the second occasion they'll say
You
again.
will file an affidavit. It is made sure that no further opportunity shall be granted to the director local body, and this court will be compelled to summon the concerned officer if the affidavit is not filed, since this matter relates to pensionary benefits of employees who have rendered considerable service with the corporation, and further delay will hamper their financial status, their financial condition.
I'm very grateful to your lordship.
The matter will happen.
After 2 weeks.
Lordship, it's identical other matters.
8 to 15 identical matters, I am filing the
The same order in all the matters. You are the counsel in all the matters?
No.
Mr. So and so, stay here. Mr. So and so, who appears in item number this, is directed to file affidavit in all other matters. Since he is appearing in one of the matters, his appointment shall be regularized in all other matters, which will
all matters must
which will enable this court.
Lordship, item 11, I'm for the state, Lordship.
You are for the state. Have you filed your reply?
No.
Madam, then why you are not filing your
The
reply?
last order, municipality should be filed, opposition, and there is no direction against
In which all matters you are appearing?
item 11, Lordship.
Only one?
Only
You
one.
are appearing in one?
I'm in 10, madam.
My lord, item
10. Item 9,
My lord, in item 14, I am appealing.
my different
Give,
matters, different
give
state-
your appearances and file your affidavit.
Okay, Lordship.
Same order, file your affidavit, madam.
Okay, Lordship. এই যে দিচ্ছি
What are the? Take down their appearances. You file your affidavit within a week.
Grateful to you, Lord.
ये बता देना वो last वाला last portion of it रखो बस बाकी तो same है. They'll file their affidavit in opposition within a period of 1 week. That's it.
Lordship, 7th May.
7th May.
Item number 16.
My lord, in this matter, my lord, I am for the petitioner. My lord, I will not take, my lord, much more time, my lord. Similar order has been passed, where, my lord, the completion certificate was not there. Your lordship was, my lord, didn't, my lord, consider the petitioner's prayer. I have, without taking any lordship's leave, একটু ধরুন, দিন এটা just.
Oh no, madam, if the completion certificate is not there, I am not in.
Yes, that order is passed, my lord, by your lordship. This is the order. একটু দেবেন just have to. But I have mentioned where there is no completion certificate. Similar order may be passed, my lord. I have not taken your lordship's, my lord, leave. Several matters are there, my lord. May I mention it?
What are you trying to say? In this matter, the present matter.
Present matter, my lord, 10, 12 matters, my lord, there is no completion certificate. So, my lord, similar order may be passed.
No, I will not pass that similar order, madam. Sorry.
But, my lord, then.
You have taken me for a, this is not right. These matters, you should go and file civil suits to recover your money. Money suit should be filed.
My lord, this is
disputed question of fact, I cannot get into.
Yes, that is the observation of your lordship, my lord. It is your lordship's judgment, my lord. Your lordship's judgment. And this is my affidavit of service, my lord.
Well, final same judgment, same order.
Same order, my lord.
May I humbly submit, my lord, one second?
Yes.
These 28 matters will take some time, my lord, because there are three categories, my lord.
Yes.
There is one category with limitation, the other one is with a completion certificate,
Yes.
and the last category is no completion certificate and no limitation, my lord. So, my lord, these matters will take some time. Kindly, my lord, fixed at 1:50 now, my lord, prior to rising, my lord, because Mr. Bandyopadhyay will come, my lord.
Why?
But
For
he
what?
will address your lordship, my lord, and assist your lordship.
This is only one matter, item 8.
No, my lord.
Yes, my lord, several matters are, my lord, there is
Series of
no
matters are
completion
there from
certificate.
item 16 to 43 onwards. My lord, we have prepared a chart, my lord.
Yes.
On the last occasion, Mr. Bandyopadhyay appeared to your lordship and my lord submitted that we shall prepare a chart indicating the categories, my lord.
Yes.
The chart is ready, my lord. I'm sorry, my lord, the left portion is a bit illegible, my lord, due to the paucity of shortage of ink, my lord. From item number 16 to item number 18, there is no completion certificate. Item number 16 is barred by limitation. 17 is no limitation, no completion
My
certificate.
lord, in 17, my lord, completion certificate is there. They have already paid during the pendency of this, my lord, REIT application. Only, my lord, security deposit I am paying for. If your lordship kindly direct them to, my lord, pass the security deposit. And, my lord, up to, my lord, 29, there is no completion. So, similar order as, my lord, passed in 16, same order may be passed. There is no completion, my lord.
So this is all dismissal. What is the
Yes.
difficulty?
What is the difficulty?
It is all dismissal. Mr. Na, 16, item 16, and 17, she's saying that money has already been paid, only security deposit
Yes.
has not been paid.
Yes.
Well, then I have to take instructions on these two.
All right, 17 and 18.
No, 18, there is no completion.
No completion. 18 also 16, 18.
Millard, 18 to 29, that is Millard for dismissal.
Okay.
For dismissal?
Dismissal is due to limitation.
So 16, 18 till 29.
18 to 29, my lord.
Yes.
Similar matter, whatever order you lost, Millard.
From
On
lender
Millard, 30 is for security deposit, 30, 31, 32, 33, 33 and 35. Up to 35 million dollar security deposit. Principal amount has been paid by the corporation. And Millard, Millard damage period already over 3 years. Only Millard security deposit. I have already Millard filed the form.
And 36?
And Millard from 36 to 43, all are Millard completion certificates are there. Millard, if your lordship direct me to place Millard, I will place the matter.
36 to 43.
36 to 43, Millard completion certificates are there.
So, Mr. Bandyopadhyay, item 60, it's a dismissal matter. Dismissal matter.
Right.
Dismissed. No completion certificate. All right. Item 17, she's saying that payment has been made, only security deposit is left.
We do not know.
All right. So you can take instruction to this effect.
Or my lord, if it can be sent to the commissioner for taking a decision with regard to giving it is.
My lord,
Security deposit to her.
kindly pass this order, my lord.
All right. So
In respect
this
of
is 17. 18 to 29, she's saying can be dismissed.
So 18 is also no completion
No,
certificate.
I have already stated.
Dismiss.
18 to 29 dismissed.
Just a minute, madam. 18 to 29 dismissed. All right. 30, 31, 32, 33, 34, 35 security deposit.
Security deposit.
But these are all beyond limitation.
Security deposit.
Security
All
deposit.
beyond limitation.
But so long we are making
See,
difference.
as far as security deposit is concerned, that is something which is shouldn't be part of the limitation.
My lord.
She's not asking for payment in terms of work. This is security deposit. You can take instruction. I will not pass any order. Security deposit, you take instruction.
Let it be to the commissioner. I have already filled up
And then
form.
36 to 43.
36 to 43 completion certificate.
Completion certificate is there.
Your lordship already passed order, Miller. Similar order may be passed.
Yes, 36 completion certificate is there, but 39, 40 and 41, serial number 39, 40 and 41 in my chart.
Yes.
These are all colored
beyond the period of limitation.
See, limitation as far as writ is concerned, that is no ground. If the money suit is filed, limitation will work.
Yes.
Yes, I bow down to your lordship, my lord. But in 226, my lord, limitation per se will not apply. But the petitioner has to approach within a reasonable time.
So in this same order can
However, my lord, since your lordship is categorizing the matters, my lord, I will not make it
Yes.
over complicated. I'll reserve my I came with some arguments. I'll reserve it for an appropriate matter.
So in this, the representative, I'm not passing an order that you have to give the money. I'm passing an order that you consider the representation.
And with regard to security
whatever-
deposit, we'll take instruction, come back.
Yes. Security deposit, you can take instruction.
Milord, all the security deposit,
All the security.
all the security. So, Milord,
I know item 8, 17, 30, 31, 32, 33, 34, 35
his majesty will appear on Friday.
on Friday.
Friday.
Next week or Friday?
Next week.
Next week. Let him take instruction.
So, Milord, kindly fix a date. That will
Next Tuesday.
Yes,
sir.
next Tuesday.
Next Tuesday, my lord.
Tuesday.
Simplify police.
ये सौरभ इसमें थोड़ा you have to use digital.
Milord, that I don't have to do. That's অর্ডারটা আছে
ভট্টাচার্যান কো
না না এইখানেই হ্যাঁ ভট্টাচার্য
Well, we can provide it in the meantime. But we have the dismissal order.
না না ডিসমিসাল না
Yes.
my lord. Sorry, my lord, sorry. My lord, I'm sorry, my lord.
WP নাম্বারটাও নেই
My lord, I'm sorry.
STF না আমার কোনো দায়িত্ব নেই।
Yes. My lord, here and now, my lord, within 15 minutes, I will.
You give that order.
I'm giving
Sorry.
the order. My lord, kindly, my lord, mention this, which matter will come under this order.
এটা হচ্ছে ওই সিকিউরিটি
এখান থেকে এটা হচ্ছে ইনস্ট্রাকশন
জলদি যাও, জলদি যাও।
এটা হচ্ছে ইনস্ট্রাকশন ঠিক আছে এইগুলো কনসিডারেশন কনস্টিটিউশন লাগবে কি আনবে সেম ম্যাটারে নোট করতে হতো সেম ম্যাটার আমি করে
My lord, kindly mention the date. Matter will appear on Tuesday.
রাত্রি
My lord, I'm grateful, lordship.
যাইনি আমরা কিছু ওর সুবিধার জন্য যেটা আমি আরো কম্পিটেন্ট লোক থেকে দিতে পারতাম যেটা ও রোজগার হয় চেম্বারে তারপরে যে আমার বাবা লিডার
Minutes, I am, my lord, submitting this. I'm waiting here. This matter, my lord, where the completion certificates are there, item number, my lord, C 36 to 43. And here and now, my lord, I'm giving this.
প্রত্যেকটা মামলা দিই তোমাকে আসেই মনে হয়
Grateful, my lord.
এটা মামলা দিয়েছিলাম না 1 নম্বর
Mr. Bandapachai, the defense of limitation and all you can take in the speaking order.
Well, I was about to, I did not want to interrupt your lordship. In the matter, your lordship is remanding back for consideration. Kindly keep all points open only.
Absolutely, all points are open.
My lord, previously they argued before Honorable Justice Amrita Sinha, she didn't accept that limitation point. I have that, my lord, judgment with me.
Great, madam, we are not saying anything.
My
We are
lord.
only saying that you decide the representation.
Decide the representation. My lord, they have already completed the
At
work.
various stages, various years, various arguments are made depending on how what we read around.
Honorable Chief also has passed an order.
Yes, all
I
the
think
judgments are with
couple
me.
of days back. where he has rejected this.
And my lord, very recently, my lord, we have found an order of division bench of Allahabad High Court, my lord, which is extremely elaborate. It discusses the law on both the sides. Ultimately, it holds in my favor. That's a different thing. But the discussion is there for us to use. What the propriety? Yes, I understand. For the sake of propriety, my lord, but my lord, for my learned friends years also, my learned friend was saying that I had made some argument. It was rejected by Malajaji Sinha. But in a matter of KMC, Malajaji Sinha has been pleased to, my lord, with the same arguments, have been pleased to reject the writ petition. But at the same time, I agree that there are two paragraphs which says that state or instrumentally should not act in this fashion as a bad paymaster, because there is some faith on these organizations when people go and work. But at the same time, on merit, the writ petition has been dismissed.
Same like, state should act like a
Model employer, absolutely.
My lord, I am filing all the affidavit of service. My lord, I am here and now, my lord, I am giving that judgment. My lord, I am waiting here. Lord, this is the order where your lordship is pleased to, my lord, allow this application. My lord, this is the order. Passed by your lordship, my lord. Please, my lord. It any element? Grateful, my lord. It any element? Forgive any element.
All right, first order in all the matters.
Only.
Now 44.
At 44, I led by Mr. Shokosari Chatterjee, kindly got pass over, my lord.
Passover won't be possible. Who's for the corporation?
I'm not for.
Who's the respondent?
Respondent is also not present, my lord.
There are two petitions.
Second one is my application where I will proceed, my lord. 44, my lord. 45, my lord.
Not today. Not today. We'll have it next week. Next week?
Next week I will proceed.
Not today. Both the matters not.
45.
44, 45 same.
46, my lord. I am for the petitioner, my lord.
Yes.
Last occasion, my lord. Heard this matter, my lord. This is the matter, my lord, where the petitioner daughter was died in a road accident in front of my lord Jew hospital. My lord.
Yes.
After that, last my lord heard and direct my learned friend to take inspection, my lord. Whether
Lordship, the issue here is that the petitioner's, the deceased expired at Bombay. And the cremation certificate was issued by Calcutta because the burning commenced before the here. Kashik Mitra burning ghat. This is the situation. We have issued the cremation certificate, but the difficulty is that at the time of issuance of the cremation certificate, we have taken the original documents from the petitioner to issue the original certificates regarding the like the postmortem reports and others documents, your lordship. Now the difficulty is that the petitioner cannot get the death certificate because the Bombay Municipal Corporation is perhaps seeking the original documents. So lordship, what we can do is we can we can give the original certificate, original documents, provided he gives the Xerox copy of all the documents that we have kept on our record, making it certified to be true. Because death certificate has to be issued by the Bombay Municipal Corporation. But apart from this, your lordship, in the writ application, the petitioner has never uttered a single word, nor has annexed any document showing that he has placed any representation before the Bombay Municipal Corporation, or any answer has come forward by the Bombay authorities.
I have stated that I have
that has
went there and tendered.
Pleading, but no document has been relied upon.
I went there tendering my lord all documents. They had refused to accept the my lord. Coming my lord, here I have stated.
Your purpose will be solved if they give you all the documents.
But পারপাসটা ই হবে তো বোম্বে থেকে অ্যাপ্লাই করতে পারবেন তো
বোম্বে থেকে অ্যাপ্লাই করতে হবে, কলকাতা থেকে ডেথ সার্টিফিকেট পাওয়া যাবে না।
My lord, what he is telling, he is the father of the deceased, my lord. If he went to Bombay, go there to Bombay, my lord, they have told them within 3 months he has to apply, my lord.
That is
3 months is over, my lord. My lord, what is
That
the
he has to
difficulty? I do not know, my lord. Petitioner is a permanent resident of my lord, Kolkata district, North Chowkis Pargana, my lord. They have issued a death certificate from here. It is not difficulty, my lord, for them.
Death certificate cannot be issued from Kolkata because the death commenced at Bombay. Cremation certificate দিয়ে দিয়েছি তো আমরা। কর্পোরেশনের ডেথ সার্টিফিকেট হবে না, ক্রিমেশন সার্টিফিকেট হবে স্যার। ক্রিমেশন সার্টিফিকেট হবে। ডেথ সার্টিফিকেটটা স্যার এখানে আমাদের যেটা আছে
এখন বম্বেতে
because your lordship, if anything happens, then your lordship, then he can sue.
What are you saying, Mr. Bandyopadhyay?
Well, it is if the cremation is there, that who is giving the certificate? That is controlled by any cremation base by the municipal corporation.
Right.
If this is done, this cremation certificate is the origin of the death certificate.
Oh, that's right. But what they are saying is that the death has taken place in Mumbai. Death has taken place in Mumbai, and the Mumbai, and the cremation has taken place in Calcutta.
Is here.
There has been a postmortem also.
Show me the law.
Huh?
Show me the law.
Death certificate. আরে এখানে লেখা আছে।
But what stops you from What stops you?
Registration Act.
Show the birth and
Registration Act, the
What are we for? 540, 440.
Let's hear, my lord. Special provision as to registration of birth and death of citizens outside citizens, my lord. I am citizen, my lord. This is they are stating that outside India. My lord, I am reading, my lord. Any register of charity who neglects or refuse without reasonable cause to register any birth or death occurring in his jurisdiction or give a certificate to the informant under section 12 or to submit any return as required.
Lordship, under 7.2 and 7.4 of the Birth and Death Certificate Act 1969, death certificate has to be issued from where the death commenced.
where is it written, madam? Is it written in the
Lordship,
law?
in the KMC Act also it has been stipulated. I'm just
Show me.
7.4 or 7.2 এখান থেকে দেখান এক মিনিট দিন আমাকে section 7.2 and 7.4 Lordship, 7.2 says that every registrar shall without fee or reward enter into the register, maintain for the purpose all information given to him under section 8 and 9 in respect of births and deaths which has taken place in his jurisdiction. So here the jurisdiction comes in Mumbai. This is, my lord, I'm referring to the Registration of Birth and Deaths Act 1969.
Show me, madam.
7.2 and thereafter, your lordship, 7.4. And in the KMC Act also, it has been stipulated to bar করে রেখেছি বইয়ের মধ্যে 7.2 আর 7.4 of Registration Act. আর এখানেও আছে, আমি এখানে দেখাচ্ছি স্যার আপনাকে। আরে এখানে 359 বোধহয় খুব সম্ভবত। ডেথের ক্ষেত্রেও ডাক্তাররা যেখানে হয়েছে সেখানে হবে। প্রভিশন আছে। Provision to pay.
This is just recording of the birth and death. That doesn't mean that you can't issue a certificate. You have recorded his death. Cremation is also a record of death, madam.
Lordship?
Cremation is also a record of death.
Cremation is also a record of death.
So what is
On
the
the basis of the
difficulty?
documents, but the difficulty, lordship, the pleading, the prayer that has been sought for by the petitioner, your lordship, is that the petitioner is seeking the original documents because he is not in a position to get death certificate from the Bombay Municipal Corporation. We can forward the original documents, your lordship. We have no difficulty.
To issue the death certificate also, madam. It is the right to the responsibility to return with the original death certificate with the relevant to the which is the direct the responsibility to by considering representation of the petitioner issue death certificate of petitioner daughter forthwith.
349 or 359.
Well, this they took place at Bombay, my lord. After that body was returned to Calcutta, my lord. Everything was completed in Calcutta, my lord. I am a permanent resident of.
Sir, you don't do any law, don't do any research.
All right.
You just come here, give lectures. It is for the court to do all your homework.
Provision আছে আমি দেখেছি। তুমি বইটা দেখো। 459 না 459 এরকম একটা প্রভিশন আছে। বম্বেতে মারা গেছিল। Lordship, let us come back tomorrow. I'll satisfy your Lordship with the relevant provision of the KMC Act. Lordship,
You also do some
459.
homework.
It is Lordship, it is 459, your Lordship, the medical practitioner to certify.
Come back
the cause of
tomorrow, madam.
death.
Do some homework.
এটা রাখুন, এটা
Affidavit of service. Just give back that cash, not.
Friday.
না, না, কালকে।
original side day, full day.
Tomorrow is Thursday, Friday.
Friday.
Tomorrow is original side day.
Then my lord, can it given on Monday, your lordship?
Monday.
না, আমি শুক্রবার তোমার NC.
Monday.
Grateful, your lordship.
Keep it on record. Affidavit, you take it back, the affidavit, sir. Give it on Monday. 8-2, that is, in respect of birth and death, the institution
found inside in a public place. The baseman or other for
459 টা বল করো।
it has been occurring.
এক second.
that is the problem. That is the reason why they are not giving it.
Lordship,
They
under
say death has taken place, so you get the death certificate from there.
Lordship, under section 459 also.
This is the, he has to notify.
So, then they have.
I will also read and
Lordship,
let me help.
as per
Let me see,
459, it is the medical practitioner to certify the cause of death.
That is in 8-2 also, man. 8-2 of death.
459 of the KMC Act.
Same provision is there in the registration of death and birth certificate.
So the
That also.
person who has attended his illness and by a duly qualified medical practitioner, such practitioner within 3 days of his becoming of such person sign or forward to the officer in charge a certificate of the cause of such person's death.
But that's all right.
That is they're not doing. That is his difficulty.
He is not doing it. It is done by the officer.
Officer in charge of the Bombay authorities.
If he informs him, then what is your difficulty?
He is not informing.
No, with proper
All right, you come back on
He
Monday.
sue before the Bombay authorities also.
Monday.
Say the all problems are. মানুষের সমস্যাগুলো সমাধান করে করবো।
Next.
Number 47 and 48.
For the petitioner, the statement that I want.
The matter in the nutshell is that petitioner is the legally wedded wife of the deceased person who was appointed as a group D staff in Calcutta Municipality. In the year 2017, in an accident during the officers, he succumbed to death. From that date till today, the petitioner has been deprived from the family pension, gratuity, PF, as well as the compassionate appointment. Several times I had made representation before the municipality for providing the death benefits, but
What is the other petition?
it's
Other
the
petition
mother-
filed by the mother.
By the mother.
Mother of the deceased employee.
But she also wants the death benefit.
Yes, my lord. I also claim for 50% of the.
You are asking for?
100% death benefit. Because at
So
first
one
I-
is mother, one is son.
No, I am the
Wife. So one is mother, one is wife. Very interesting. Both of you want money. Son is gone,
I am the
husband is gone.
definitely. It is
You are the mother,
no. I am
you are the wife, and you are the mother.
The wife left her matrimonial home long ago. Now after death, his claim.
Even if she leaves long ago, as long as she is legally valid wife, she's entitled. Unless until there's a divorce.
No, there is no divorce as per law.
Kindly have a look at
She's
page 7,
valid.
para
She's
7, my lord, page
the
4.
rightful owner. Sorry?
Page 4, para 7. I don't want to leave the in-law house or the matrimonial house. I was ousted from the house after the death of the husband. I had made the amendment in para 7, my lord.
So sir, mother has no right.
My lord.
No, mother is the nominee of the his son's, her son's service, mother. She is the
Where's
only nominee.
Where's the nominee letter?
The service book is there, mother. Nomination is page 20. Page 20 of my writ application, my lord. There is a second writ application. Terms of nomination. But I obtained succession certificate. In the succession certificate, proportionate share has been also been you see.
Yes.
Page 30 onwards. Page 29. Page 29.
You have not participated in the succession
party, but I failed to participate. At the end of
because
the
she
day,
left,
in the MACC,
she was no relation with the family, madam.
no, no, not made the party.
Yes, I made
They
party.
made your party, you never participated.
My lord.
So you gave up your right.
No, no, I have not given it. It's ex-party. Kindly have a look at the order of my lord.
No, but where have you challenged it, sir? Where have you challenged it?
That is.
So
I just bow down before your lordship. But what has
So why have you filed this?
She is residing in.
Oh, sir, whatever it is, you are a lawyer.
Now she has come. Before that, I was not there.
You are not the right forum.
No, even if it's so.
Challenge this.
My lord, even if it's so, kindly have a look at page 29 of my learned friend petition, my lord.
Yes.
It's death gratuity, GPA final payment, and promotional arrears. The learned court has not given the widow pension or the family pension to the mother of the petitioner, to the mother of the deceased employee.
Sir, till the time this succession certificate is there,
My lord.
you are entitled for what?
My lord, in succession, it is several judgments are there, my lord.
Yes.
But successions has been made only for the testamentary documents. And if I agree with that, the death gratuity, GPA, final payment, and promotional area that they can claim.
In writ petition, I will decide all disputed question of fact. Right? Right?
Several judgments are there, my lord.
Where disputed question of facts are decided.
But the family pension cannot be given to any other as per the DCRB rule. The first inherited by the spouse.
Where the spouse has failed to even contest for the succession certificate.
No, they only prayed for the gratuity, GPF, everything, but they are not prayed for the family pension, my lord.
All right, file your replies. We'll see that. Nothing to be done. Yes.
May I make one thing? What I found is, one is relying on a succession certificate. It's quite obvious they are successor. Other one is saying in exclusion of the mother and father that she is entitled. My municipal authority also said, I will do this, I will do that. But really, none of us has looked up the law. The law, what will be substantive law in the matter which will be applicable. What all they are claiming is immovable assets. Moment it is a immovable assets, then Hindu Succession Act will come into play. Moment the Hindu Succession Act comes into play, then under class 1 legal heir, predeceased son and the widow. For the predeceased son, mother and the widow, both are the class 1 heir. Since Succession Act. Since both are the class 1 heir, so obviously the right is 50-50. Now, one is challenging that I have a nominee. Nominee is not the right to get money. Nominee is to receive the money for the disbursement. Like in case of a will, we appoint an executor. So, in a simpler form, here she was appointed as a nominee to take it and then to disburse. It might go to the creditor, it might to wife or son, whatever. So the basic law is, it has to be, both are class 1 legal. If your lordship kindly takes up the, if your lordship kindly takes up this law, then if you,
Yes.
Then lordship kindly come to the class 1 legal heirs. Lordship will find for a predeceased son, not the father, but the mother is the class 1 legal heirs. So, one money which has been distributed just by their mother with, the municipality has divided in between two 50-50. But then I found that the law holds the field is Hindu Succession Act, and then both are entitled 50-50. So, lordship, this is the position of law.
Yes.
And now I leave it to your lordship how lordship will deal their application, because I'm a municipality, as your lordship will direct me, I will. But lordship, we always usually try to see who were the dependent on that service. Because once we talk about a family pension, we never talk about any other things. We talk about the dependents. So in exclusion of two old persons, one will take the money. Whether that will be equitable or not, lordship will decide it.
Right.
The substantive law is this, and lordship, so far equity is concerned, whether she stays or not, whether she is good or bad, we will not go into it. But it has to be by this proportion of law is 50-50.
You file your reply. Bring this on record, file your reply. We'll decide on that basis.
We can file a small report on it. Instead of going into reply, then I have to deny. And I am not in a position to deny or admit either of the allegations. Because that was a private matrimonial allegation.
Admittedly, my claim is 50%. As my learned friend have said. In the writ petition also, I have claimed 50%.
I think the law, you have done the correct thing.
What my learned friend has told.
You want 100%, right?
Family pension 100% definitely as per the DCRB rule, my lord. Kindly have a look at the DCRB rule. First, I am entitled.
Show the rule.
I have already provided in the earlier occasion, madam.
So, lordship, what we can do is, whatever is not disputed, they are taking 50-50, let it be disbursed. And so regard to this, we will file and then we will litigate.
Yes, my lord, that will be better. That will be better.
There's a dispute for everything. I will not pass any order because they want 100%.
100% regarding retirement fees as well as pension, both.
He is waiting for the time to become the 500.
Very well.
I have waited for 7 years.
If you wait for few more years, you might get the interest.
He has waited for 36 years for the husband.
I have every faith before this honorable court that it will not take 7 years. DCRB rules in the family pension, first the spouse.
I think this is the
And-
right case to send it to the mediation so that they can really understand their legal proposition and then they should proceed. Otherwise, they will litigate.
Dependent family members are entitled.
if the mother, if there is a single son, then there should be a consolidation. There
No,
is
no,
a-
let's not go by the equity, let's go by the law.
Who is also working, so.
But he is
the
not the,
mother cannot claim that
he is-
he
he
is
is-
only dependent upon the deceased employee.
that son is not the
deceased son.
dependent, the dependent family members. He has independent family. So he cannot claim.
For that reason,
So
I read the-
dependent parents are also, they can also claim. Dependent
it's a fifth. First
Yes.
I have to, or
for the
What is the-
purpose of family pension, wife in the case of male employee, husband in the case of female employee, minor sons including adopted son, unmarried minor daughters including adopted daughters, and dependent parents.
Yes.
So these are all
Let-
categories
let-
who can claim.
let
So your
them give the
reading is
reply.
wrong.
Let them give the reply. I have every judgment. Where I.
Sir, your
where I
reading
show
is
the
wrong.
Supreme Court has upheld that
You see this.
Cannot override the Hindu Succession Act.
Supreme
It
Court
is
has
not.
specifically,
It is not.
when the wife is alive and she has not remarried, then the wife is entitled for the.
Sir, this rule doesn't say so. The one you are relying upon, doesn't say so, sir.
None of the rule can override the statute, Malak.
I can show the judgment in this regards.
Raise the judgment, then why didn't you show the judgment? Show the judgment. We'll have it on Tuesday. Come with the judgments. Not today, Tuesday we'll have it. Let's see what judgments. he
Tuesday,
makes.
next Tuesday.
Next Tuesday.
Lordship, 29 and 30. Lordship, 29 and 30, I will be out of station, Lordship, if your Lordship. First or second, Lordship, whichever suits, Lordship.
29 and 30. We'll have a second. Second?
Yes, Lordship.
Second.
Second May, my lord.
Lawyers appearing for the state is requesting to pass at least a single line order.
Learned counsel for the petitioner seeks time to take instruction. Let this matter be listed on second. Second.
Both the matter, 47.
40.
Yes, both the matters. Both them.
I'm declared.
Sort it out between yourself, sir. Sort it out between yourself. Don't be so greedy in life. Work it out with your mother-in-law and finish it off. These are matters not to be
I will
litigated.
request my learned friend to use his good conscience, read the law. If you still feel that your client is entitled, then fine.
Sort it out. You can really convince.
Let me
Sort it out.
have a.
They both need financial assistance. And it's about a death of, somebody has lost a son, somebody has lost a husband. Use your good offices to sort it out. There's no point litigating.
As per your lordship's direction, I will.
Please try to resolve.
I'm deeply obliged.
Item number 49.
Lord, 49 for the petitioner, my lord.
Well, in this
Lord,
matter, Ms. Shoma
matter-
Chaudhary is appearing for the respondent, kindly fixed at 2 p.m. my lord. For his personal
Lord-
preparedness, he has not reached till now.
Not reached. He's
Well,
at home.
My lord, he is going on doctor's chamber for his medical test. He has come on.
We'll have it on Tuesday.
Lord, 2 p.m.
Tuesday, sir.
Tuesday. Well, Monday, lordship, kindly.
Monday.
Monday. My lord, third one is, my lord, my learned friend is there, my lord. That, my lord, PPO has been issued. He has completed his part, my lord. Only the municipality, lordship, kindly 51, serial number 51.
In all the matters, same lawyer for
Same lawyer. Municipality same.
Monday.
Usually same. Or, my lord, if it is taken up, my lord, Friday, my lord, because the pension matter.
52.
Pension matter, my lord.
Okay.
Friday, my lord.
Friday.
Grateful.
হ্যাঁ হ্যাঁ Ms. Shoma.
49 to 52.
9 থেকে 50
Friday. Yes. No, same position or
Same.
ফ্রাইডে মানে 25।
Next. 53.
I am appearing for the Kolkata Municipal Corporation, led by Mr. Devjit Mukherjee.
ये आइटम क्या है? 50. Yes.
53.
Unauthorized construction, you want it to be regularized. Yes,
Yes,
madam.
but, I tell your lordship, Lord, I must point out before your lordship, Lord, this, prior to this representation, Lord, representation was made. And we have not heard back from the corporation, but challenging the order of demolition, we have moved up in appeal before the Honorable Division Bench. This prayer was turned down. But Lord, the subsequent development has happened. The corporation has initiated demolition proceedings,
Very
and
good.
1.5 floors out of the 3 floors have been demolished.
Good.
So, Lord, I want to bring on record, Lord, by way of filing a supplementary affidavit.
Not in this matter, sir. Yes. You withdraw this. Learned counsel for the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn.
But may I make one prayer, Lord?
Yes.
But Lordship will kindly give me one liberty. I want to make a fresh representation. If that
I will not give you that liberty.
There are 54.
I am for the
Lordship. I am on behalf of the petitioner, Lordship. My senior Mr. Bhattacharya is engaged in another matter in courtroom number 25, Lordship. Kindly may fix this matter on 2 p.m. Lordship.
Proxy counsel so and so appears and states that the main arguing counsel is in some personal difficulty. Let this matter be listed on. When do you want, Mr. Das?
Next week, madam.
On Tuesday.
Lordship, grateful, madam.
Item number 55.
I am for the petition, madam. Here is a simple just a direction upon the municipality. I have
What is
already
appearing?
Mr. Shamol Kumar Das. I had contacted him. He's telling he's on his legs, my lord. Kindly have a look at page 13A.
Titagarh. In
Well,
that,
we have sympathy because what
yes,
happened.
just a
always-
minute, just a, in that list, yeah, AC sahab,
Dada, rakche.
in that list, put Mr. Mr.
Kumar Das.
Shamal Kumar Das name, Titagarh. Take his number.
I appear on behalf of the state in this matter, my lord.
Yes, Mr. I'll tell you what I'm doing. I've got a list. I've got a list where I'm taking all the municipality lawyers' number and name.
I already put it.
You have already. Very
Well, I only 2 minutes ago, Barricades and Pitagor, I already
good. You know, because sometimes when they are not there, we can call them. Yes.
During COVID period, I can remember Justice Shorkar was there in group 5. And I was in the home just taking the lunch. The court officer just called me asking Justice Shorkar, apnake appear, she is asking to appear. I just, without any things, I just told that I am taking my lunch. Oh, Pritam, take on the lunch. After that, come before this court.
It's convenient for us to call the lawyers. Yes.
Very helpful to all members of the board.
I just beseech your lordship to kindly have a look at page 13.
Presently admitted fact, pension payment was released by the authority. In respect of municipality, there is no aid. We collect property tax from the industry, but basically, the Titagarh municipality is cosmopolitan town. The several jute mill was there, now closed. That reason, my lord, we are not able to pay him. Well, kindly allow me some time. We shall pay him. My lord,
since
there is
2020,
no dispute at all. No
I'm not
dispute.
How much time?
My lord, at least, my lord, I had a talk with chairman, at least 4 months time is required.
4
Because
months?
we approached the state government to provide some fund to the municipality. Because the jute mill and other industries now closed there, the Titagarh municipality depend upon the property tax. There is no aid, my lord.
You
We
close
have
down?
to pay it.
You have to pay.
Other case, the like, education institution, the treasury department pay it. But yeah, in case of municipality, our fund, my lord, we have to pay. That's why, my lord, my lord,
Since 2020, I am just,
lordship, my lord, kindly
I am
allow
just,
sometime we shall pay. My lord.
4 months, I am a patient of arthritis. I have already,
Within 4 months.
4 months
Before
is
that.
too long.
pension is also held up, my lord.
2 months is
For
too
the
long.
last 5 months, I am not getting the pension.
You're not even paying the pension.
Both we shall pay, my lord.
The
Pension is
you have to give
if-
pension. What are you
if-
saying? I'll attach your commissioner's fees.
If the
The
municipality,
the salary of the commissioner will be attached.
everybody is getting the salary.
I'll attach it from the commissioner's salary.
Well, we are,
Pension, I'll attach
we
it.
are unable to, my lord,
I'll
pay the
attach your
salary, the
commission.
salary
I'll attach your
last-
commissioner's salary.
Last 2 months.
In the
Yes,
matter
I-
of Bhatpara municipality,
I will
similar-
attach your
Also,
commissioner's
similar
salary.
situation happened to Bhatpara municipality.
where,
Same thing.
where
Pension.
Justice Sarkar has halted all the
Pension.
services of the municipality.
Pension, you have to.
Kindly allow me sometime, we shall pay.
I can, I can
We have
accept,
full sympathy to the petitioner.
I can accept the
full sympathy.
I can accept the municipalities that is regarding the gratuity, they will take 2 to 3 months.
Pension, you
That-
have to
but
continue.
pension, it is impossible, my lord. How could I
Pension, you have
survive?
to continue paying.
ठीक है payment gratuity within 4 months gratuity submitted
Not 4 months, my lord. Kindly have a look
What-
since
what is-
2020, my lord. If there
Gratuity
is no
within
fixture,
means but within means the last date is 4 months,
Gratuity
before
within-
that
within-
before that we can pay my lord.
Gratuity within 2 months and pension to be immediately released.
within 7 days, my lord, kindly. Along with the
Not 7 days, my lord, but
backlogs.
kindly request some
Along with the
Pension-
backlogs, my lord.
Pension within 2 weeks, along with all the backlogs.
kindly my lord
No, pension.
save
has-
us, kindly save
No,
us.
no, then your commissioner is getting the payment.
Everybody is getting the salary.
Commissioner is getting salary.
No, last few months, my lord, no fund.
Commissioner is getting his salary or not.
The commissioner 2000, my lord,
Whatever it's so.
Whatever it is,
2000.
whatever. Payment has to be made.
Commissioner are getting 2000 there, my lord.
Don't have this. I will not. Pension, you have to make the payment. The petitioner has preferred the present rate.
Well, let the matter be kept pending for 2 weeks because let the pension be released.
All right. Petitioner has preferred the present writ petition being aggrieved by the inaction on part of the respondent municipality, whereby they have failed to release the gratuity amount to the petitioner who has retired from the services on 30th/10/2020. Further, it is contended by the counsel for the petitioner that he has not been paid his regular monthly pension. Learned counsel with the petitioner submits that the petitioner and his wife are both senior citizens and are suffering from various medical ailments. Due to the non-grant of gratuity amount and irregular payment towards monthly pension, the petitioner is in acute financial difficulty. Full stop. Learned counsel for the respondent municipality fairly concedes that the municipality is undergoing deep financial crisis and is financially in a difficult situation to make payment to its employees. Full stop. He further contends that since the municipality is only dependent on the collection of house tax, they are ridden with financial burden and are unable to carry out its functioning. He prays for 2 months' time to pay out the gratuity amount due to the petitioner and ensures this court that they shall make the monthly pension payment as well as the arrears due to the petitioner within a period of 2 weeks from the date of passing of this order. Full stop. We can dispose it off. What is the point of keeping?
Let the monthly pension be provided in 2 weeks. After that, my lord.
Let this matter be listed for compliance after 2 weeks.
My lord, kindly records the state is also represented, my lord.
If you are
For the state, my lord.
Then kindly direct the state to give funds to the municipality.
And kindly provide some funds.
we
already approached.
also has appeared for the state. It is the financial condition of the municipality is well known to the state, and it is expected of the state to ensure that the employees are, that the pension and the gratuity amount of the employees are paid on time, and they shall not suffer financial instability and burden despite having served the state for considerable period of time. Full stop. Let this matter be listed on after 2 weeks.
7th
May.
Develop.
Petition number 56.
But happy for the state.
Lordship, petitioner here, a 69-year-old lady whose husband joined KMC in the year of 1975. After 32 years of successful service, he was appointed as a assistant assessor collector to a particular KMC unit. On 2007, a particular financial year ending, he was arrested for 12 days and then released on bail for a crime which obviously he has never committed, and he has not understood the reason also. However, after 2007, he fought the battle till 2023 and died while the adjudication was pending. After 8 months of his death, the order came out, judgment came out, and the co-accused, 2 persons were accused, the co-accused, and he obviously got acquitted. During the entire time of his, that from 2007 to 2023 till his death, he was suspended. He has applied after the bail also. He was not absorbed in the service. However, he was given a 50% subsistence allowance. He was neither given any pension after his retirement. From 2007, he got retired in 2011. So sequence is 2007 arrest, after 12 days bail, 2011 retired, fought the battle till 2023 and died, and acquitted in 24 after 8 months, unfortunately after 8 months of his death. Now we have approached KMC also. After several reminders, in page number 61, last annexure 11, in a single sentence, they have refused the claim without citing any reason. I am to inform you that your prayer has been declined by the competent authority of KMC without citing reason. We have given all the documentations of the judgment also. So our petitioner is having one unmarried daughter, one unemployed son, 2 daughters are married, only one person is maintaining the entire family. So our appeal is to release the pension, widow pension, arrears, gratuity, pending salary with arrears and interest, whatever my lordship can order.
Take down.
I appear for the Kolkata Municipal Corporation.
What is this?
I'm not satisfied with the communication as made. I'm not satisfied.
You
Because
decide his representation. I'll set aside the communication.
no, that communication, because that communication, it will not help my learner because this communication
One
ultimately.
line communication.
That's right. That's it. It should be said aside. The two things, the reasons to be communicated to him, because he says the competent authority. He's a merely, my lord, communicating authority. The person, my lord, who has my assistant as a collector. That has not been, my lord, refused by the competent authority. That is a different authority. But while, my lord, making that communication, he has not given the reasons, but not, my lord, forwarded. Therefore, what I am submitting, my lord, the reasons for refusal by the competent authority to be communicated either to him, my lord, or he also asks us to ascertain the reasons and to submit a report that I can do. Or he also may direct that one line communication is not sufficient because it's a mere communication, not the refusal, reasons of refusal, because it says competent authority has refused.
Lordship, challenge is not
See the sentence.
This is the letter which he has received.
No, this is the letter by the assistant collector, not by the competent authority to who
We have
decided
sent
the issue.
We have sent the letter
He's not the issuing authority, but considering authority.
Ghosh, when you are making the statement, then you communicate the reasons.
Yeah, but I'm
There are the
submitting.
reasons.
But I am to ascertain the reasons that then either it to be communicated to him or if lordship wants us, my lord, I can ascertain and to my lord come up with the report to your lordship that these are the reasons for which, my lord, this has been communicated.
Mr.
I
Ghosh,
do not.
you
my
should have got the reasons.
No, reasons, of course, my lord, with the file, definitely, competent authority to whom it was placed, but he is not the authority.
You have to communicate those reasons to him.
Whether
you have reasons or not.
Well, I will communicate. That is, I am submitting you should direct the authorities to communicate the reasons to the petitioners of refusal, because he is the mere, the authority to communicate.
You decide his representation.
My lord.
Take down. The petitioner has preferred the present writ petition, praying inter alia for the release of the retiral benefit of her deceased husband. Full stop. It is the case of the petitioner that her husband was an employee of the Calcutta Municipal Corporation. Full stop. During the tenure of his service, he was arrested on 4/4/2007. 4/4/2007 in connection with special case number 03
Lordship
/2012.
My lord, can I say one thing? My lord, if it again goes to KMC, I have researched and went in. We have given the notice to commissioner, councillor, mayor, everybody. They will give us a writing documentation which will again that lady will die now. That man has died without justice. That lady will die. Lordship,
So what do you want, sir?
that later justification of the letter we don't want. Our petitioner wants the pension. The widow pension should be started immediately, Lordship.
Without they're deciding the representation, this court should pass an order that you are entitled for it.
No. Okay. I beg you. I beg you.
Likhwaya. Special court, Alipur. Full stop. Petitioner's colleague, one Mr. Ashish Kumar Mukherjee, was also arrested in connection with the said case. Full stop. Allegations against both the officials were the same. Full stop. Both the officials were suspended pending investigation. Full stop. The petitioner's husband superannuated from service on 31/1/2011. Full stop. He died during the trial on 14/6/2023. The trial on 14/6/2023. Full stop. Subsequently, the criminal court, the court by its judgment. Subsequently, the court by its judgment dated 21/3/2024 acquitted Mr. Ashish Kumar Mukherjee as well as the deceased Mr. What is the name of this person? Deceased Mr. Devrata Dirbhangi. It is the In view of the same, the petitioner had submitted various representations before the respondent authority for
জিনিসটা আছে সেটাই তো জানাতে বলছিলেন হয় যশোর আমাকে
considering
পাঠাতে বলুন
her
এরা তো
pensionary benefits.
কমিউনিকেটিং অথরিটি জানিয়ে দিয়েছে আর কি।
Full stop. However, by letter dated 2012-2024, respondent had rejected the said representation. Being aggrieved by the same, the petitioner has preferred the presented petition. Full stop. This court has heard the argument advanced by the parties and has perused the records. The respondent by letter dated 2012-2024, informed the petitioner that the petitioner's request has been rejected by the competent authority. Full stop. However, no reason has been assigned for the said rejection. In view of the same, this court is of the considered view that the order dated 2012-2024 is bad in law, as no reason has been assigned for rejecting the petitioner's representation. Full stop. Order dated 2012-2024 is hereby set aside. Full stop. The respondents are directed to consider the petitioner's representation and dispose of the same by way of a speaking order after affording an opportunity of hearing to the petitioner. Full stop. Needless to state, the petitioner shall be at liberty to challenge the same in accordance with law. With the above direction, the presented petition is disposed of. Affidavit of service
13
is
June
taken on.
2024, the representative that is to be taken into consideration.
Representation dated 22. What is the date of the representation?
13 June, my lord, that was my lord, reference was there in the communication.
What? 13th. Sorry? 14th November. That is the reference in the letter, right?
No, reference my lord, 13 June 2024.
13th
The
June.
communication,
13
my lord, the
dated
communication which was
13
made.
June 2024.
No, that.
We will decide the 13 June. 13 June. 13 June.
13 June.
Right? The representation dated 13 June 2024.
In June 2024.
2024. Next.
Item number 57.
For the municipality.
In the territorial limits of the Jangipur municipality, which is the respondents herein before your lordship. My lord, if your lordship takes page 22 straight away, my lord. These are 3 photographs which we have annexed. What has happened, my lord, is that in front of the property, steel barricades have been installed by the municipality. And this is the 3rd round of litigation since 2021, my lord. My lord, the first round of litigation was filed by one of the tenants of our property, my lord, who had filed a writ petition before this honorable court, asking the directions, asking for necessary directions upon the municipality to remove the steel barricades, which is blocking the ingress and egress to the entire property. My lord, order was passed in the said writ petition by this honorable court. By the time the writ petition was taken up for consideration, my lord, upon being served with a copy of the writ petition, the steel barricades installed in front of the property had been removed by the municipality. My lord, as such, the writ at that stage had become infructuous. My lord, the first order is at page 20, my lord. The first order passed by the coordinate bench of this one. 2020.
Yes.
My lord, if your lordship takes page 20, my lord. This is the first order in 2021. None had appeared on behalf of the municipality, my lord. But if your lordship takes paragraph 3 of the order, my lord, the municipal authorities have taken care that the entrance to the shop room of the petitioner is not blocked in any way. The further prayer of the petitioner for the change of alignment of the pavement cannot be entertained at this, as this step has been taken for public interest, and such actions of the authorities for public good and beautification should not be interfered with. The grievance of the petitioner has been addressed. The ingress and egress to the shop is free. However, it is made clear that the entrance of the petitioner shop shall remain as it is, and further obstruction shall not be placed in front of the door, blocking free entry and exit from the main road. My lord, subsequent thereafter, my lord, on May 20, 2023, again the steel barricades had been installed in the similar fashion, my lord. This gave rise to a second writ petition which was filed by the petitioner before your lordship, my lord. and an order had been passed on April 3, 2024, which is at page 31.
Yes.
Lord, at page 31, Lord, if your lordship takes paragraph 2, Lord, the municipality was not represented on that day also, Lord. It appears that in previous round of litigation, at the instance of the tenant of the petitioner on the similar issue, the court in such and such, video order dated October 7, 2021, directed the entrance of the petitioner shop room to remain as it is, and further directed the obstruction should not be placed in front of the door, blocking free entry and exit from the main gate. The photographs annexed to the writ petition suggest that the free entry and exit to the petitioner shop room has been infringed by the railings that have been put in front of the said shop. An objection has been filed by the chairman of the municipality, which is pending consideration for a long period of time. As the municipality is not represented, the issue cannot be decided conclusively. In view of the above, the chairman of the municipality is directed to consider the objection filed by the petitioner in the light of the order passed by this court on 7th October 2021, after giving reasonable opportunity of hearing to the petitioner or an authorized representative at the earliest, but positively within a period of 60 days from the date of communication of this order. But thereafter, the representation that had been made by us has still not been considered. We have made another representation before the municipality, seeking similar reliefs for removal of the barricades which block the ingress and egress totally to the petitioner's property, my lord. No recourse have been taken by the municipality.
Yes.
Kindly produce my report. I have handed over copy to my petitioner lordship. My lord will kindly seize that I shall place the report lordship. As per site verification, it is observed that Ratna Dosh, that is the petitioner herein, which is bearing plot number such and such, which is a G+2 student building, encroached the municipal land bearing number bearing RS 368 LR plot number such and such by 7 feet on the west side, which is demarcated in the map by pink color triangle portion. The passage measuring with 5 feet for ingress and egress of the petitioner. Most of the encroached land belongs to the municipality. That's the municipality demarcate their own land by providing steel railing. Lordship will kindly come to the map. The next page, Lordship. Just sketch map.
Yes.
My lord will see is the yellow portion is the municipality road and municipality market passage, Lordship. Now, my lord will kindly see is the pink portion. The pink portion is the area which has been encroached by the petitioner, Lordship. That is my instruction. And my lord, there is a red line over there. This red line indicates that railing that has been put forward. My lord, the shops which are there at the left-hand side of the pink portion, those are the shops that are owned by the petitioner, lordship. Now, this pink portion has already been encroached by her. If we do not put any steel railing, lordship, they will again encroach the remaining part also. This is the market complex.
Why didn't you decide the representation by the earlier?
Lordship, there has been a problem. Lordship, kindly direct. Can we sometime, lordship? We shall dispose of the representation, lordship.
Decide the representation. Why?
Lordship. I agree, lordship. Kindly direct and grant us some time, lordship. We shall dispose of the representation by passing a decision order after giving an hearing to the petitioner.
My lord, may I make one submission, my lord? I cannot stand in the way of the representation being disposed of in accordance with law, my lord. My lord, but one thing that transpires from this report itself, my lord, today I have perhaps or allegedly encroached upon the municipality or the municipality's premise or the road owned by the municipality. My lord, to that, my entry and egress and ingress to my property is blocked by a barricade. My lord, it is a barricade.
You have encroached upon.
Allegedly.
So go to the civil court because this court cannot.
Yes, my lord. Good, my lord. Perhaps I am not.
Rights.
My lord, I am not asking.
Yes.
My lord, I am.
Decide the encroachment. Not today. The ingress and egress cannot be blocked by a barricade.
Ingress and ingress is not blocked. They will decide your representation if you want that. Otherwise, I'll relegate you. It's a disputed question of fact. I'll dismiss your petition. You go wherever you are.
Lordship.
Take down. The present writ petition is challenging the action of the respondent municipality whereby the whereby the steel barricades have been put in front of the petitioner's shop situated at holding number 157/144, Fultala, PO, Raghunathganj, Ward number 20, Murshidabad, which thereby is causing obstruction in the ingress and ingress of the to the petitioner, to the petitioner's shop. Also, it is the submission of the learned counsel of the petitioner that earlier also in the year 2021, respondent municipality had installed similar steel barricades in front of petitioner's shop, which was challenged by the petitioner in, which is the first writ petition?
The first writ petition, Lordship. It was
challenged by the petitioner in writ petition
Page
number
20.
16529 of 2021. However, even before the said matter was listed, the respondent municipality had removed the steel barricade, full stop. In view of the same, the said writ petition was disposed of by order dated 7/10/2021, directing the respondent municipality that the entrance to the shop of the petitioner shall not be obstructed, blocking his ingress and ingress. Full stop. Thereafter, there was no barricade till 2023, right? Till 25/2023. Full stop. On 25/2023, the municipality had again installed the steel barricades, and the petitioner challenged the said action of the respondent municipality in another writ petition number 16186 of 2023. Full stop. While order dated
3rd April
3/4/2024, the said writ petition was disposed of by directing the respondent municipality to consider and decide petitioner's representation in light of the order dated 7/10/2021, passed in the earlier writ petition 16529 of 2021, after affording an opportunity of hearing to the petitioner. Full stop. However, till date, neither any hearing has been given nor any order has been passed. Full stop. In view thereof, the present writ petition has been filed, wherein again the petitioner is seeking similar relief. Full stop. The petitioner has again filed a representation dated 19/8/2024. Full stop. Though his earlier representation, what was the date of the earlier representation?
18th April 2020.
18th April 2024 is still pending, and no decision has been taken on the same. Page 24. That was the representation to be decided by them.
Page 37.
उसको छोड़ दो, वो लाइन हटा दो, ठीक है? Learned counsel for the respondent municipality appears and states that they will carry out the directions passed in the earlier order, wherein the municipality was directed to decide petitioner's representation. Full stop. He assures this court that necessary compliance of the earlier order shall be done within a period of
Lordship may decide. Any period,
within
Lordship,
a period of 4 weeks.
Lordship.
Full stop. In view of said statement, nothing survives in the present writ petition. The petitioner shall be satisfied if his earlier representation is decided. With the above direction, the present writ petition is disposed of. वो जहाँ first writ petition है ना, which is the number is 16529, right? Earlier, by another set of वहाँ जो है ना, first writ petition was filed by another shop owner, another tenant of the shop. हाँ, वहाँ पे ऐड कर देना बस, जहाँ petition लिखा है ना, by another tenant of the shop.
मतलब the report file may be kept in the record.
The report is kept on record. The report filed by the municipality is kept on record. I'm not deciding, I'm not getting into that encroachment.
Grateful, extremely grateful, Lordship.
Now 58.
I'm for the state, Lordship.
I'm appealing for the respondent number 4.
Allowing unauthorized construction without keeping it manageable open space back on the wall of my premises. The private respondents are also admitted the owners with respect of the property which I own, the petitioner own. Your Lordship kindly sees I have added some photographs also. Photographs also. For intended just bang on the wall. Can you see the photograph?
Yes, let me see.
Page double.
Lordship, we have obtained a sanction plan from the Calcutta.
Cases are pending. On the same cell back, civil cases are pending.
We are not getting into the civil cases.
Yes, madam.
Who appears for the corporation?
That's
Which corporation is this?
Kachrapada municipality.
देखना भाई इसमें कोई लॉयर है?
No, no.
Which corporation is this? You serve them, sir. Find out. Serve them. No, that's all right. Affidavit of service is taken on record. Learned counsel for the petitioner is directed to serve the so and so municipality again afresh. Serve them afresh. List on Wednesday. Next Wednesday.
I will disclose number 4. My appearance.
Which state is also present, Lordship? Grateful, Lordship. Wednesday. Grateful, Lordship. That the state is present, it to bolo.
Yes.
Item number 59. Things here, then you take care of those that. Another order of safeguarding. I guess this order
There is deviation, they have to demolish it. We have taken.
No, but if they are not demolishing it, you demolish it.
You not new demolition. If he said they are saying that here deviation specifications are not given. No, specifications of deviations are not given. That is their point, main point. So we have passed a new order maybe, but same demolition has been ordered. And fact is, this were not.
But have you identified the deviation?
Yeah, so far as the deviation is concerned, we also need not require to mention that. Because there is a division based specifically judgment on
Number 60.
on this.
Can see now.
No. That I can
Point out, but that is not my main point. The main point is below.
Learned counsel for the petitioner seeks time to file additional affidavit, supplementary affidavit, bringing on record the new demolition order which has been passed by the corporation. Let the same be done within a period of 1 week, list after,
A copy of it served out.
with an advance copy to the council for the list after 2 weeks.
2 weeks. Grateful year.
7.5.
But Mr. Banerjee, the notice should contain the deviation. The notice should contain deviation. That is what I'm not expressing any views on it, but to my understanding, the notice should always.
I log out your lordship. I have told that deviation.
Private.
Then why don't you pass another order?
I don't know.
Order has been passed wherein the corporation has specified the deviated portions here.
Yes.
I am for the private.
Deviated portions certainly. So their division, but we will not point out when we have rectified it and passed the order. Let them carry out the deviation, demolition of the deviation. Let them carry out. Because they are now coming on technical points. If your lordship dispose of the matter directly me to pass a space order, I will pass. No problem.
We'll see that. Let them bring that on record. We'll see.
But we have passed noting the deviation. Now they come, say no, we have made a point there, the deviations are not given, now you cannot. But deviations will be there. I am only that I am just inspection report was not. What? How can they rectify that? I am asking myself, how can they rectify the deviation?
We'll keep.
They will continue. They will continue. And not only that, but not small deviation. 500 square feet, 400 square feet.
Not to decide.
This will go.
This will go.
Items
60 mala is a very short matter.
very short.
Mala, I have another matter fixed at 2 p.m.
Well, I am appealing.
What do you want? I should have lunch.
Mala making not today. Mala,
I
petition is
appear
not
for
a
the state lordship.
If it's a short matter, I can do it. I'll have lunch late.
2 p.m. I have one matter.
We'll do it now, sir.
Here in now, Mala, I am.
Yes, tell me, what is it?
So, my lords, Mala, 60.
Yes.
In this matter, Mala, in this matter, I appear on behalf of the, my lord, the private respondent number 9. And in this matter, I have filed, my lord, this the application for, my lord, the appropriate order of development, my lord, the subsequent fact. My lord, herein, my lord, the unauthorized construction made by the private petitioner, my lord. My lord, the lodge a complaint before the authority concerned pass a demolition order. Now they have challenged the order before the, my lord, the tribunal. Tribunal dismissed his my lord, the appeal. Then they came before this honorable court. My lord, Justice Amrita Sinha also, my lord, the dismissed their petition, challenging, my lord, the demolition order. So now they prefer an appeal. Appeal also dismissed in, my lord, 2023. Then we file an, my lord, the contempt application. Now the last occasion, my lord, Justice Amrita Sinha on 10th of April, my lord, 2025, my lord, the authority concern has come with the, my lord, before the, my lord, Justice Amrita Sinha given undertaking that the demolition, my lord, the process has already been going on and it will be, my lord, the completed within very short time. My lord, after considering their submission, my lord Justice fixed the matter on 8th of May. Now they have filed this writ petition challenging the, my lord, the order which has already been attained its finality in the appeal court. Now I ventilated the subsequent document which has not been, my lord, the annexed with the.
So there's nothing pending now?
Nothing. Matlab
That
the matter-
RVW which was filed,
Why-
RVW
matlab the
number,
corporation can say.
RVW 178 has been decided.
That's pending, my lord. Pending
It is still
before the
pending.
tribunal, my lord.
Tribunal is
The
the
next
review.
date, my
Taking into consideration of the review application, my lord, just division bench held, may are pending, or it is that the demolition order has been passed in 2020, 12. This,
You said short matter.
nothing, because it's the process is going.
Next week.
Lordship, I
Next.
represent the state if reports is
Next week, madam. I'm not passing any order. Next week.
online order, my lord.
Proxy counsel so and so, Mr. So and so appears and seeks a short adjournment. Let this matter be listed on next week.
Grateful, my lord. Grateful, my lord.
Next Wednesday.
No.
Grateful.
Not short, complicated,
Not complicated, madam. It's infractuous.
not infractuous. It's pending.
61.
That the order issued whereby the order passed by the district magistrate under section 40 under Surfacing Act was set aside by the DRT. And in the pending of the petition, my lord, the auction purchaser filed one contempt application before the DRT. Now I am taking the contempt. Under that compelling circumstance, I am mentioned. This is my case, my lord. I am also bring to the notice of the.
You're for the bank.
I am for the bank, man. Secure data for the bank.
Refund the money.
This my learned significantly auction part.
Refund the money.
That is the question, my lord.
Refund the money.
Whether I am liable to refund the money or not.
You're liable to refund the money.
That is a short question involved, my lord. May I, my lord? My lord, if I bring the my lord the background fact, my lord.
What is the fault of the auction purchaser?
Sorry, my lord.
What is the fault of the auction purchaser?
There is no fault, but there is no fault of the bank either.
Oh.
And my lord, that is why, my lord, the sale notice is a very paramount function. Because, my lord, in the sale notice, in all the cases, when the sale notice is published, it was within their knowledge that the possession is not with us. Now they cannot make insurance that they bought the property under the impression immediately to be handed over to us. But that is why, my lord, in each and every sale notice, we mention the property as is valued as whatever it is. So, my lord, the property was encumbered at the time of auction sale was very much within the knowledge of the auction party. Subject to correction, my lord, I do not come across any provision of law whereby a limited period of time has been prescribed by the Act within which I have to give possession to the auction party. Now the question is whether I am diligent or not. That is the sole question, my lord. Now, if I find the dates, my lord, within the time, my lord, the sale notice was published in March 2014. Sale certificate was issued in the month of May 2014. Immediately we went to the district magistrate, and in July 15 itself the order was passed in our favor. So far from March to July we are within time, and we are pursuing the case in due diligence. Now thereafter the litigation starts. Now the borrower challenged that order passed by the district magistrate under section 40. If that is so, and if the parties are in the litigation, whether this is a fault of the bank or not. Now, for argument's sake, my lord, if I go by the law of equity, that it is not their fault either, and they are now claiming the refund, my lord, then why, my lord, I am fastened with the extra liability of interest as well. Now, the DRT has said that I have to refund the money along with, my lord, rate of interest, which is, my lord, available of my lord, the fixed deposit. Now, my lord, the second leg of argument is, my lord, suppose, my lord, the section 14 was set aside. Now the DRT could have allowed me to go for second, my lord, this thing for auction sale. They could have easily waited for the. Instead of that, my lord, the matter was challenged before the DRT and DRT. Now the question is whether the section 40, the order passed by the district magistrate under section 14 is, my lord, good or bad. If I manage to produce before a logical relevant commission, support of my claim that the order passed by the district magistrate under section 14 was good, then perhaps I am secured, my lord. May I, my lord, place the order passed by. That is the order, my lord. That is the running page.
comes in force, then
the order passed by the 38 and 39. Before, my lord, I place this order. May I give another big fact, my lord. When this order was passed, before going to the DRT, my lord, by the borrower, they first came to this very honorable court. The order of this honorable court passed by Honorable Justice Dipankar.
But Justice Datta has only delegated you to DRT.
Yes, but that order did not find any fault with the order passed by the district magistrate. Only that because of the alternative remedy, you have to go to the DRT.
He has not expressed anything. Just prima facie view he has taken.
They
are not appearing.
Yes, my lord.
My lord,
on the last topic.
I am not at fault, my lord. Actually, the borrower came to this honorable court.
You are for?
I am for the auction, but the borrower is. My contention is that there is a nexus, maybe. Because, my lord, they are section 14 order was set aside only on one technical ground, saying that the learned magistrate said
that I am delegating the power of taking possession to the bank. The DRT said that according to the Honorable High Court's orders, the district magistrate will have to take possession and then hand it over. They could as well as filed a separate application, fresh application. It was a technical defect. They went against that order to DRAT. Now they have challenged and they have kept this petition pending since 2023, Lordship. So, my lord, what diligence they are talking about? And I am an auction purchase 2014. Substitution also they did not do. And borrower is not coming before my lord.
My lord,
Yes.
is not prejudiced because the borrower has not challenged the order of the DRT before the DRS.
But he is on joint possession.
Party, my lord, at the instance of in terms of the order passed by Justice Sinha, my lord, I have filed that internet application, my lord, for the purpose of substitution. I have sent the notice to the my lord, the proposed legal heirs, my lord, the ability of services. So, for the merit of this case is this, my lord, whether the law permits, whenever a section 14 my lord, order is set aside by the DRT or DRT, whether law permits immediately for the refund of money to the my lord, the auction party. Whether it is a question put to myself, my lord. I could not come across any provision of law. That is my understanding. Now, second, my lord, the thing is whether the order passed by the DM was at all, my lord, faulty or not. Nowhere, my lord, the DM passed, delegated the power to me. What the DM did, my lord, was that the directed the Commissioner of Police to take up the possession and my lord, to ask me to take up the
By giving all this commentary, it doesn't help me. Let us go through the document. Keep showing the document whenever you are making any submission. First, you were showing some single judge order. What?
Yes, my lord. The order passed by this honorable court, so far the
Yes, which page?
yes, my lord. That is at page number 40, my lord. Starts at page number 40. That is the order, my lord, passed by Justice Divakar.
What do you want to show in this order?
My lord, this order, my lord, did not find fault with the order passed by the district magistrate in terms of section 40.
Read it. Where is that?
I have the next, my lord, internet page number 241. I have considered the decision cited by the learned advocate for the petitioner, bearing in mind the nature of challenge thrown to the impugned order. I have also ascertained from the learned advocate representing the bank that it had indeed filed an affidavit of the nature required by the first proviso of section 14 of the Act, together with the application that was filed thereafter. Having heard the learned advocate for the party, I find no reason to interfere at this stage in view of the alternative remedy that is available to the petitioner under section 17 of the Act. That is my
So,
thereafter,
no finding.
Thereafter, my lord, the decisions of the Supreme Court reported in such and such has laid down the law that an appeal is available under section 17 of the Act against an order passed under section 14 thereof. In Protima, this was cited by the my lord, the borrower. This bench had interfered with the order passed by the district magistrate Bardwan on the ground that the district magistrate could not have abdicated his duty by directing the superintendent of the district police force to provide assistance to the secured creditor for the purpose of taking over possession of secured assets. Such direction it was said should not have been issued despite introduction of subsection 1A of section 40. In the present case, the Commissioner of Police, however, has been directed as follows. Thereafter, the order of PM has been reproduced. In view of the order, the undersigned being the authority under section 14 of the Surface Act, read with Rule 8(1) of the Security Interest Rule 2002, authorizes to take over possession of the secured property mentioned above, making necessary inventory. You are requested to render police assistance as and when required for the purpose. Thereafter, there is no direction that the possession of the secured assets shall be taken by the secured creditor. That is the finding of this honorable court. Instead, the direction appears to be on the commissioner to take possession with police assistance. Therefore, the decision of Protima Roy is distinguished. Next, Mala. Insofar as Mr. Satyayan Agro Industries Supra is concerned, the learned judge had interfered on the ground that the additional district magistrate, without having the necessary authorization to make an order under section 14 of the Act, had authorized a resolution agent of the secured creditor to take over possession of the secured asset with the assistance of the police and officer of the land and land reform department. That is definitely not the case. The decision in Aroti Kormokar and others interfered with the order passed by the district magistrate non-24 personnel on the ground. The such order did not bear any reflection of consideration of the affidavit that the secured creditor had filed before the district magistrate, and without reference to such affidavit, the nature and extent of satisfaction
This by the district magistrate would not be designed. The judicial notice can be taken of the fact that district magistrate North 24 Parganas has been passing orders which are cryptic even without referring to any affidavit of the nature that is required to be placed or simply relying on an order passed by the Honorable Court at a stage when Section 14 was not amended. It is for such reason that the orders passed by the district magistrate North 24 Parganas in most of the cases have not found favor with this bench. In the present case, it is clear from the exhumed order that the same has been passed by the district magistrate Howrah on scrutiny of documents submitted with the application, and upon reading satisfaction that the petitioner, that the debtor of the respondent bank, secured creditor, has received the demand notice under Section 32 of the Act, despite expiry of the statutory period of 16 days, the liability was not clear. And there being the failure on the part of the borrower to discharge his liability in full, the situation was ripe for the secured creditor to invoke the provision of Section 14 of the Act. Omission to refer the affidavit by itself would not render the order bad, particularly when it is a claim of the respondent bank that an affidavit was filed. But it was a categorical finding of the Honorable, is my answer. For the reason above, there is no question of entertaining this petition. It is, if at all the petitioner is acted by the order of the district magistrate under Section 14 of the Act, they shall be at liberty to approach the relevant tribe. And thereafter, my lord, the parties went to the DRT and the order was launched. Now, if my lord, the order impugned before your lordship is placed before your lordship, then I can perhaps satisfy that that order is not, my lord, good either in law and may I, my lord?
Yes, yes.
The order impugned, my lord, is at page number 167 to 179. Now, the initial part was the production of the case agitated by both the parties. I am not, my lord, reading all those parts, my lord. Another aspect I may just, my lord, mention that neither Section 13(2), means the demand notice, or my lord, the possession notice under 34 was challenged by either of them. That remained active. Which, my lord, comes to page number 171. That is internal page number 5. Now, the learned DRT, why this the appeal was referred before the DRT? Because DRT came to a finding that the order of learned the DM was bad by citing those decisions. But the DRT did not direct us to refund the money. So they, my lord, preferred the appeal because they did not get the order of refund, and we went in an appeal before the DRT because we had taken that order 14 order back. So should I pass the DRT order or DRT order?
Show the DRT order first.
Yeah.
Page 121, Lordship. One 121.
Initial parts are, my lord, the fact of the cases, my lord.
Sorry?
Initial part of the order was, my lord, the facts of both the cases. I am not reading that one. I am reading the operating part. That is, my lord, 123. Where the finding of the DRT starts.
Yes.
I have heard the learned counsel for the parties and gone through the papers, document my observation and findings are as follows. The applicants have filed the present essay on such and such that they challenging the district magistrate order dated such and such. The respondent bank has issued possession notice dated 12th of July 2012, copy annex. The respondent bank has issued e-auction notice dated such and such, copy annex. The applicant have not challenged the possession notice dated such and such and e-auction said notice dated such and such with the limitation. Hence, the tribunal is the opinion that the applicants are not entitled to raise irregularities, illegalities in the possession notice dated such and such and e-auction sale notice also dated such and such. In the present essay, in the purpose of availing the statutory remedy under Section 17 of the Act has lapsed. This part, my lord, nobody has challenged. Hence, the scope of essay is only with regard to district magistrate order dated 23rd of July 2018. On the issue of irregularities, illegalities of the district magistrate order dated 23rd of July 2015, the district magistrate, however, in his said order, directed that in view of the above, the undersigned being the authority under section 14 of the Surface Act, read with rule 8(1) of security interest rule authorizes to take over possession of the secured property mentioned above, making necessary inventory. The district magistrate has forwarded the copy of the order to the authorized officer of the respondent bank. The material issue before the tribunal for scrutiny and examination is whether the district magistrate is authorized to give authority to the authorized officer of the respondent bank to take possession of the secured assets under section 14 of the Act. In this connection, Honorable High Court at Calcutta by decision number such and such, WP number such and such, that WP, the order was in the matter dated Sastona and agreement acid, another Indian in the matter of Protima De, though decision was referred to by the forward. As held in terms of section 14(1) of Surface Act, the district magistrate shall take possession of the secured asset and hand over the same to the authorized officer of the respondent bank. The tribunal is of the opinion that the order dated 23rd of July 2015 passed by the district magistrate Howrah is not in compliance of the provisions of section 14 of the Act and also not in compliance with the decision of the Honorable Court at Calcutta aforesaid. The district magistrate order dated 23rd of July 15 suffers from irregularity, illegality and liable to be set aside. The tribunal scrutinized and examined the district magistrate order dated 23rd of July 2015 and accordingly had order dated 26th of August 15 directed the respondent bank not to take physical possession of the property till next date of hearing. However, since the issue of e-auction sale notice dated March 2014 has been raised during the pendency of the essay, this tribunal is of the opinion that there is judicial necessity to record the finding of e-auction sale notice dated March 14, sale conducted on May 14. For deciding the issue of refund of sale amount of rupees 25,35,000 to the auction purchaser party in the present essay. The applicant filed the present essay on August 2015. Honorable High Court at Calcutta filed order dated April 2015 in the matter of Central Bank of India versus Devasis Modi and others, held that the security creditor is not entitled to proceed for sale of the secured assets without physical possession and secured assets. In the present case, the sale was conducted on May 14, by sale notice dated March 14 prior to decision of the Honorable Court at Calcutta in the matter of Central Bank of India versus Devasis Modi was issued and sale was conducted in May 14. The applicants have not challenged the sale notice dated March 14 within the limitation period. Applicants are not entitled to raise irregularities, illegalities of sale notice between March 14 being time bar. The tribunal has already observed here and above that the district magistrate order dated July 15 suffers from irregularities, illegalities and liable to be set aside. The respondent bank is not entitled to take physical possession of the property in question in view of the order dated July 15. As regards the prayer of the auction purchaser added party for the refund of sale amount of 25 lakhs and all, tribunal has observed herein above that the property in question was sold by sale notice dated March 14, sale May 14, and the respondent bank has issued sale certificate on also in May 14. There was no essay filed within the limitation period of pending before the tribunal raising irregularity, illegality of the sale notice dated March 14. Hence, the tribunal is not inclined to scrutinize, examine whether the measures taken for sale of the secured assets are in accordance with the provisions of the Act. The respondent bank issued sale notice dated March 14 and sale conducted on May 14, issued sale notice in favor of auction purchaser accordingly. This auction purchaser party has not been able to get physical possession of the property in question during the last 4 hours. Then the pursuant to the sale of property in question and issuance of sale certificate as mentioned above, the respondent bank shall consider the legal issues whether respondent bank still holds the status of security creditor and the whole security interest over the property in question and accordingly shall decide the issue of refund of the sale amount to the auction purchaser added party at their end. The tribunal is not inclined to intervene in this issue and pass any order and leave the issue to the respondent bank to decide judiciously for deciding the issue of refund of sale amount to the auction purchaser added party. Now, in respect of prayer of the auction purchaser made in I number such and such for refund of sale amount of such and such, the tribunal is of the opinion that deciding the issue of refund of sale amount gives effect to the setting aside of sale notice dated such and such as ordered herein above. Since the tribunal declines to scrutinize, examine the irregularities, irregularities in the sale notice dated such and such being not challenged by the applicant within the limitation period or sale notice was not the subject matter of any essay pending before the tribunal is not inclined to pass any order on refund of sale amount to the auction purchaser and added party. In these circumstances, the tribunal holds that the view of the tribunal is not the proper forum for adjudication on the issue of refund of sale amount as paid for by the auction purchaser party in their IA number 13, sir, the auction purchaser party may raise this issue in proper judicial forum for getting remedy. Well, this was the my lord, the crux of this order, though it held that they are entitled to, but the DRT refused to pass any order directing us to refund the amount. Now, my lord, we also agreed by this order because this order held that my lord, the order passed by the DM was bad, also held them to entitle for refund. So, my lord, the refund. So, my lord, we preferred the appeal and they also preferred the appeal. And after analogous hearing of both the appeals, my lord, an order final decision was passed by the DRT on
DRT of
Order, DRAT. DRAT order is that
even the DRT order, where does it say that why the order of the district magistrate is wrong, not in compliance with section 14?
Lordship,
relied upon only those previous
Those two judgments.
Lordship will kindly
But
see.
how are those judgments?
My lord, let him complete, my lord. I will just show the salient
So let-
features.
let-
Let him complete, my lord.
Yes, please tell me.
May I place the DRT order?
No, but DRT order, what have they relied upon? Those two judgments.
Yes, my
But
lord.
how are those judgments?
Decisions, my lord, those decisions which were distinguished by this honorable court by Justice Datta, those same decision was relied upon by the DRT. And another finding was that the possession was not with us. In spite of that, my lord, we held the auction and sold the property. That is not the law, my lord. It is settled. I am bringing the decision, my lord. The sale can be conducted both before auction as well as rather possession can be taken both before auction as well as after auction. My lord, it's settled law, my lord. I can satisfy that. And so far, another aspect is this was just all those decisions, my lord, which were distinguished by this honorable court, were relied upon by the DRT. Now the DRT affirmed the DRT order, but on some other ground. And what is the other ground, my lord? May I, my lord? Page number 171, my lord.
Starts at page 167.
Paragraph number.
Yes.
Paragraph number 9. Landed DRT recorded a finding that as far as notice allocated 32, 34 are concerned, they are not challenged by the borrower guarantor during the period of litigation. Hence, statutory remedy under section 17 of the Act has led. It would be pertinent to mention that neither borrower nor guarantor has challenged the finding of this landed DRT. Other limb of the order relates to the legality of the order dated passed by the district magistrate Howrah, wherein the landed DRT opined that the order is not in compliance of provision of section 14 of the Act 2002. The landed DRT placed reliance upon the judgment of Honorable High Court in the case of Swastian Agro Industries versus Government of India, then Pratima Roy versus Union of India. Accordingly, the landed DRT set the order passed by the district magistrate. Landed counsel for the appellant auction purchase and submit that the impugned order is bad in law. Landed DRT has placed reliance upon two judgments of the Honorable High Court. It is submitted that the Honorable High Court in Howrah Light Casting versus Central Bank of India held that the decision of the Honorable High Court Calcutta in the case of Pratima Roy is distinguishable. Further, the Honorable High Court has held that the decision of Honorable High Court in Sastona and Agro Industry also distinguishable, but not applicable in the present case. Writ petition. It should have been writ petitioner. Writ petitioner with Howrah Light Casting was filed challenging the order of the district magistrate dated July 2015, passed under section 14 of the Act of 2002. The writ petition was disposed of with the liberty to the appellant to approach the DRT under section 17 of the Act 2002 on the application of the auction purchaser. Landed DRT passed the order on June 2018, directing bank to refund the total amount of 25.35 lakh deposited by the auction purchaser along with the interest within 30 days. Feeling active with the order appeal number such and such was filed by the bank. It was decided on September 18, wherein it was directed that the DRT should decide the matter expeditiously and the order dated June 18 was set aside. Subsequent thereto, Landed DRT passed the impugned order setting aside the order of district magistrate passed in July. At the very outset, it appears that the landed DRT was persuaded by two judgments of Honorable High Court. One is Swastian Agro Industries and another Pratima Roy, for setting aside the order of the district magistrate dated July 15. It would be relevant to mention that the Honorable High Court in a decision in Howrah Light Casting, that is the order, my lord, passed by Justice Datta. Howrah Light Casting specifically held that there is no direction that the possession of the secured assets shall be taken by the secured creditor. Instead, the direction appears to be on the commissioner to take possession with police assistance. Therefore, the decision in Protimaro is distinguishable. Further, it was held that insofar as software and agro industry is concerned, the landed judge had interfered on the ground that the additional district magistrate, without having the necessary authorization to make an order under section 40 of Act 2002, has authorized a resolution agent of the secured creditor to take over possession of the secured asset with the assistance of the police and officer of the land and land reform department. That definitely not the case. Both the decisions were distinguished by the Honorable High Court, but landed TRT has placed reliance upon those judgments which is against the principal judicial discipline. Judicial discipline requires that finding an order of Honorable High Court has to be followed in letter and spirit by all authorities, including judicial authorities subordinated to the High Court. When specifically both the case laws as referred to above were distinguished by the Honorable High Court in the judgment cited above, and they were not relied upon, then the learned TRT was in error to place reliance upon the judgment in the order. Accordingly, as far as the aspect is concerned, order of the learned TRT requires consideration of this tribunal. This tribunal is of the opinion, is of the confirmed view that the learned TRT was wrongly placed reliance upon the judgment of Sattan Agro and Protimaro. Now the question arises as to whether the finding regarding passing of the order of landed district magistrate can be upheld or not. Provides to section 14 of subsection 1 provides that where the possession of any secured asset is required to be taken by the secured creditor, or if any of the secured assets is required to be sold or transferred by the secured creditor under provisions of this act, secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing the chief metropolitan magistrate or district magistrate within whose jurisdiction any such secured assets or other documents relating thereto may be situated or found to take possession thereof, and the chief metropolitan magistrate, or as the case may be, the district magistrate shall, on such request being made to him, take possession of such asset and document relating thereto and forward such assets and documents. If we go to the order passed by the landed district magistrate dated July 15, we find that the aggregate amount of financial assistance granted and total claim amount of the bank as on date of filing the application is nowhere mentioned in the order. There is no satisfaction recorded by the landed district magistrate that the claim of the bank is within the limitation period as to be required as required to be recorded under clause 2 of the proviso. Section clause 5 proviso provides that there should be a declaration that consequent upon defaulting payment of the financial assistance, the account of the borrower has been classified as the NPA. It is also not mentioned in the order that the landed district magistrate provisions of the Act of 2002 and rules made thereafter complied with or not also did not find place in the order. Further, Rule 1A provides that the district magistrate may authorize any officer subordinated to him to take over possession of the asset. Impugned order shows that it was addressed to the Commissioner of Police, Howrah, wherein it was stated that in view of the above, the undersigned being the authority under section 14 of the Act 2002 authorized it to take over possession of the secured property mentioned above, making necessary inventory. You are requested to render police assistance as and when required for the purpose. No specific authorization was given to any officer subordinated to the district magistrate Howrah for taking possession of the secured asset. Rather, the subject of the letter shows police assistance to the secured creditor for taking over possession of secured property under section 14 of the Act. It means that the district magistrate wrote the letter to the police commissioner to provide police assistance, but no officer subordinated to him was authorized to take possession. It is in violation of section 14, subsection 1A of the Act 2002. Accordingly, the order passed by the landed magistrate Howrah is in contravention of specific provision of section 14, which could not be sustained in the eye of law. Accordingly, the landed TRT set aside the order of the district magistrate, but on different grounds. But as far as finding passing the order of district magistrate concerned, I do hereby confirm the finding, but on different grounds mentioned in the body of the judgment. Secondly, I am considering the submission made by the landed council for the auction purchaser that the landed TRT has failed to exercise its jurisdiction for passing order for refund of the sale price amount deposited by the auction purchaser. Impugned order shows that the landed TRT has not passed any order for refund of the amount, being not appropriate forum for adjudication. I am not impressed with the finding recorded by the landed TRT declining to pass any order of refund of sale price deposited by the auction purchaser. No doubt, SARFAESI proceeding was initiated by the bank, wherein secured asset was put on sale by way of public auction, wherein the auction purchaser was the highest bidder, and he deposited the amount to the bank. When the bank could not deliver possession of the secured asset, the auction purchaser had every right to make request for refund of the amount so deposited along with interest from the bank. landed DRT of the appropriate authority under section 2 to pass an appropriate order for refund, declined to pass an order amount to the receipt of refund of this amount when possession was not delivered to the auction party, that he is entitled to refund of the amount deposited by him along with interest. So, my lord, this judgment was contradicted in its own sense. At one time, it is saying the DRT was not relying upon the order passed by the honorable court. At the same point of time, it is also distinguished that same order because, my lord, if the order passed by Honorable Justice Dipankar Datta, the court was of the firm opinion that the affidavit was filed. So far the, my lord, the proviso of parties concerned, that was complied with. That finding is there. But this DRT, my lord, the landed DRT did not refer to that part. It only referred to that part, my lord, which was further suited to it, my lord, that the reason was distinguished by the DRT. Now thereafter one decision was, my lord, referred to, and the refund was, my lord, I was directed to send that refund. So therefore, my lord, I can, if I summarize this order, my lord, this order cannot be allowed to sustain for two reasons. First, my lord, it is at one point of time is relying upon the order passed by the very honorable court. So far the distinguishing of the those 3 or 4 decisions are concerned, but at the same point of time, my lord, it is not relying upon the findings of this court. So far the compliance of filing of affidavit part is there, because that order, my lord, the court came to specific finding that the affidavit was filed and it was also in order. And that is why, my lord, only the affidavit what was not used by the DM. For that reason alone, my lord, that order cannot be faulted. So therefore, that part. Secondly, my lord, even if I, my lord, for argument's sake, this part was not there. So now we have to see, my lord, whether this part which we failed to mention in the DM order, whether the DM failed to mention those part of the provisions was indeed, my lord, material or not. Because first we have to show whether that part was there or not, my lord. If, my lord, kindly place the order passed by the DM, that is the number. Cost of liquidation, my lord, I again, my lord, submit that this order has been affirmed by the honorable. Only because of the alternative remedy, my lord, the matter was implemented. Well, this is the order, my lord, under consideration, page number 38. Addressed to, my lord, from District Magistrate Howrah to the Commissioner of Police Howrah, Police Assistant to the secured creditor for taking possession of secured property under section 14 of the Act. The authorized officer of the Central Bank of India address such as secured creditor submitted an application to the undersigned praying for taking over possession of secured property under section 14 of the securitization and reconstruction of financial assets and enforcement of securities. It appears on scrutiny of documents, madam. I am emphasizing this part. It appears on scrutiny of the documents submitted with the application, that is the application on affidavit, that the said bank sanctioned a cash credit facility in favor of Mr. Howrah Light Casting, proprietor such and such, son of such and such, and then thereafter the address and all these things against secured property. Next paragraph. Property, all piece and parcel, thereafter description of property has been given with boundary. Now let's come to the next page. It also appears that the borrower defaulted in repayment of loan and interest accrued thereon, and so aforesaid secured creditor issued notice under section 13(2) of Surface Act to the borrower for repayment of the due statutory period of 60 days purportedly had been covered since the date of service of notices, but the borrower has failed to discharge the liability in full. In view of the above, the undersigned being the authority under section 14 of Surface Act, read with Rule 8(1) of security interest such and such to take over possession of the secured property mentioned above and making necessary investments. This is the order, madam. So if I put the question to myself, so where is any part of this order based, the satisfaction of the EM is lacking, madam. So far the default of loan, so far the property is concerned, so far
Only the last. In view of the above, the undersigned being the statutory so and so authorizes to take over possession.
secured property mentioned before making necessary investment.
How can you authorize the bank to take over the possession?
Yes, I also come to that one. Very good. You are requested to render police assistance as and when required for the purpose. So therefore, my lord, I have twofold submission. This order can be interpreted in a way that the subordinated authority, the police is a subordinate to district magistrate. He is the head of the administrative body, my lord, in a district, and the commissioner is or the district or superintendent police subordinated to the for the purpose of discharge of accessory function. So, my lord, I can interpret this order that though the language has been stated in this way, but it was actually the direction given to the commissioner of police to take over the possession and hand it over to me. And second part is this: if my lord, I for a second hold that no, it is not like that. It was the police was actually asked to my lord they provide the assistance, and I had to take the possession. Whether that can be also my lord can be faulted with or not. My lord, kindly comes to section 14(1). Because before I come to the provision of section, my lord, kindly come to the heading of this section, my lord. Because this is very important, my lord. This is the object, my lord, of this section.
Yes.
What is the object, my lord? The chief metropolitan magistrate or district magistrate to assist secured creditor in taking possession of secured assets. I am heavily relying upon this part, my lord. Even though, my lord, subsection 1A was later on, my lord, inserted, but my right, the authorized officer's right to take possession with the assistance of police has not been taken away. And subject to correction, my lord, that part has not been dealt with part in any decision. That I cannot take that possession. Now I will come to the other part. If my lord kindly comes to the first part of the section 1, my lord, where the possession of secured asset required to be taken by the secured creditor, or if any of the secured asset is required to be sold or transferred by the secured creditor under the provisions of this act, the secured creditor may, for the purpose of taking possession or control of any secured asset, request in writing. So I have requested in writing. The chief metropolitan magistrate, district magistrate within whose jurisdiction such secured asset or other document relating thereto may be situated or found to take possession thereof. And the chief metropolitan magistrate, as the case may be, the district magistrate shall on such request be made to take possession of such assets or document relating thereto or forward such assets and document to the secured creditor. This is one part, my lord. Thereafter, my lord, what would be the conditions of affidavit? Those have been mentioned in proviso. There are total, my lord, 9 proviso is there. The content which is to be mentioned in our affidavit. That part, my lord, this honorable court did not find any fault. In any other case, my lord, even if the order of the district magistrate has come to a finding that many of those, my lord, provisions has been there. Maybe, my lord, the other provisions we have mentioned has not been reflected in the order. I must admit. There are total 9 proviso. The district magistrate referred to 3 or 4 proviso. But that doesn't mean that, my lord, the other proviso did not comply in the affidavit. Thereafter, my lord, provided further that on receipt of the affidavit from the authorized officer, the district magistrate or the chief metropolitan magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable orders, my lord. I am again relying upon this part, my lord. Pass suitable orders for the purpose of taking possession of the secured asset within the period of 30 days from the date of application. There are another proviso, my lord. Provided also that if no order is passed by the, this part can be see that a timeline has been given, my lord. Thereafter, the third proviso, my lord. Provided also that the requirements of filing the affidavit stated in the first proviso shall not apply in proceeding before the district magistrate. That is also not applicable. 1A, my lord. The district magistrate or chief metropolitan may authorize any officer subordinated to him to take possession of such assets and documents relating thereto, to forward such assets and documents to the secured creditor. Subsection 2. For the purpose of securing compliance with the provision of subsection 1, the chief metropolitan magistrate or the district magistrate may take or cause to be taken such steps and use or cause to be used such force as may in his opinion be necessary. So therefore, my lord, if I summarize this provision, my lord, first part is the very purpose of the section was to assist, my lord, the police for the purpose of taking possession. So my right to take possession with the police has never been taken away. So for this part is there. Even then, my lord, for the abandoned person, both the district magistrate as well as the chief metropolitan magistrate also authorized to take possession and forward the documents by making inventory, and by making section 1A, even the authority subordinated to him is also authorized to take possession. My lord, the law is settled so far the Nobel Kuban and other decision is concerned. Authorized officer has the possession can be taken by authorized officer only, or if any resistance is made, then I have the right to for the purpose of filing a section 14 application. So, as far as the act is concerned, my lord, the right of authorized officer so far taking possession, either symbolic or physical, has never been taken away. It is always there. Now, the section 14 was inserted because if any resistance is there, I am not authorized to take forceful possession. Then the section 14 came. And now the chief metropolitan magistrate or the district magistrate has been authorized either to take possession himself or through me or to assist me for the purpose of taking possession. So in either of the cases, my lord, I am covered by this order of the district magistrate. And so far as my lord, this non-compliance of affidavit part is concerned, my lord, I am carrying one decision, my lord, which has held, my lord, that the act of the my lord, the district magistrate under section 14 is ministerial in nature. No adjudicatory process is to be carried out for the purpose of disposing an application of section 14. If it is a ministerial act, even the Supreme Court has held that the even no application of fine is permissible. Thirdly, my lord, yes, my lord. And thirdly, my lord, in one case, the Supreme Court also held that while passing this order under section 14, the district magistrate or the chief metropolitan magistrate can even authorize an advocate commissioner to take possession. So if an advocate commissioner can be authorized to take possession, why not the authorized officer which otherwise authorized under this very act itself take possession cannot be deprived of taking the possession with the assistance of police. And in any case, section 14 has not taken away my right to take possession with the help of the police. Only two decisions I will rely upon, madam. It is the end on forge, my lord, where
citation টা বলে দেন
2019, volume 2, SC 190.
volume 2 SCC
190. Other comes to para 23, page number 27. So this division was relied upon by the DRA in the order. Internal page number 27, mother, paragraph number 20.
Yes.
RTC Limited versus Blue Coast Hotels Limited, this court held as noticed earlier, the creditor took over symbolic possession of the property on such that thereupon he transferred the property to the sole bidder ITC and issued a sale certificate of such such on the same day, that is such that the creditor applied for taking physical possession, security and the portion of the act. According to the data section, since section 14 provides that an application for taking possession may be made by a secured creditor, and the creditor having ceased to be a secured creditor after the confirmation of sale in favor of the auction purchaser was not entitled to maintain the application. Consequently, therefore, the order of the district magistrate directing delivery of possession is a void order. This submission found favor with the High Court that held that the creditor having transferred the secured asset to the auction purchaser ceased to be a secured creditor and could not apply for possession. The High Court held that the act does not contemplate taking over the symbolic possession and therefore the creditor could not have transferred the secured asset to the auction purchaser. In any case, since ITC Limited was the purchaser of such property, it could only take recourse to the ordinary course of physical possession. We find nothing in the provision of the act that the lender taking over symbolic possession is legal. This is well-known device in law. In fact, this court has, although in a different context, has held then reasonably refer that the delivery of symbolic possession amount to an interruption of adverse possession of a party, and the period of limitation for the application of section 144 of the Limitation Act would start from the date of such delivery. This judgment also speaks of the taking over a symbolic possession under the Surface Act. The judgment will go down to discuss whether the creditor could maintain an application for possession under section 14 of the Act once he takes over symbolic possession. Because when the DRT has held that since I did not take illegal possession before auction sale, I cannot do. So that's what has been taken.
You are referring to Blue Coast, right?
Blue Coast, yes.
Your citation is 2018-15 SCC. ITC versus Blue Coast, right? It is ITC versus Blue Coast.
This judgment also speaks third line. The court referred to various authorities and arrived at the conclusion that a secured creditor remains a secured creditor when only constructive or symbolic possession is given. As the entire interest in the property not having been passed on to a secured creditor in the first place, the secured creditor in turn could not pass on the entire interest in the property to the auction purchaser. In this regard, it is important to refer to section 8 of the Transfer of Property Act. Thereafter, my Transfer of Property Act. Thereafter, my section 13 of the Transfer. Yeah, that the different intention is so expressed by the Act. As any transfer of secured asset, after taking possession thereof, such based in the transfer is all rights in the secured asset, so transferred as if transfer has been made by the owner of such secured category. It is clear, therefore, that statutorily under section 13(6), though only the lesser right of taking possession, constructive or physical, has taken place, yet the secured creditor may, by doing fail assignment, hate in the lessee, and purchaser of right in the secured asset as if the transfer had been made by the original owner of such secured asset. So therefore, my lord, before auction, before taking physical possession, we sold the property by way of auction. Thereafter, my lord, the court my lord, relied upon we may add that the notification data suggested my lord can skip that part. Then the my lord, last part, the last page, sale notice of sale of immovable property. Thereafter, my lord, this is the statutory notice that has been all my lord the secured creditor follow this my lord format. My lord, kindly see my lord.
Yes.
Authorized officer secured creditor will be sold as is what is and whatever they are. So my lord, we also while selling this property in our auction sale notice mention this part as is, where is and what is and whatever they are. So it is my lord, it is not that my lord the auction purchaser did not know that the property was not within our physical knowledge. Thereafter, my lord, this appendix makes it clear that the statutorily constructive or physical possession may have been taken pursuant to which a sale notice may then be issued under section 86 of the 2002 rules. Appendix 4A therefore throws considerable light on the controversy before us and recognize the fact that rule 81 and 82 refer to constructive possession, whereas rule 83 refers to physical possession. So therefore, my lord, my right for the purpose of sale, rather before taking physical possession, it never can be, my lord, defaulted with as wrongly held by the DR. And my lord, that possession notice has also been there, my lord. In our sale notice also we have referred to that one as is valid. And so far the ministerial act.
আপনি
আমি আপনাকে নিশ্চয়ই বলবো
ওইটাও গন্ডগোল সাইটেশন দিন
আমার কাছে দেখুন এটা
এটা কি আছে 2023
জানি না ভালো
এটাও 2023 তো কি আছে বারে বারে 2023 1 SCC 662
the two paragraphs my lord
এখন যেটা 2023
paragraph number 8 and page number 7
2023
Which, sorry, page number?
Page number 7, man.
Yes.
Thus considering the scheme of Surface Act, it is explicit and crystal clear that possession of secured asset can be taken by the secured creditor before confirmation of sale of the secured asset as well as post confirmation of sale. For taking possession of secured asset, it could be done by the authorized officer of the bank as noted in Rule 8 of the Security Interest Rule 2002. The authorized officer can always take possession of the bank of the secured asset under this rule. Thereafter, cannot take.
overruled হয়ে গেছে
Authorized officer cannot take physical possession.
Next page, madam. Second page. As mandated by section 14 of Surface Act, the CM and DM has to act within the stipulated time limit and pass a suitable order for the purpose of taking possession of secured assets within a period of 30 days from the date of its application and extended for such further period, but not exceeding the 60 days. Thus, the powers exercised by CM and DM is a ministerial act. It cannot group delay. Time is of the essence. This is the spirit of special enactment as observed and held by the court in the case of such and such. The step taken by CMM DM on taking possession of secured asset and documents relating thereto is a ministerial step. It could be taken by the CMM DM himself, herself, or through any other officer subordinated to him or her, including the advocate commissioner who is considered as an officer of the court. Section 14 does not oblige CMM DM to go personally and take possession of the secured asset and documents relating thereto. Thus, we related that the step taken by the CMM under section 14 of Surface Act is a ministerial step, while disposing of the application under section 14 of Surface Act, no element of quasi judicial function or application of mind would require. The magistrate has to adjudicate and decide the correctness of the information given in the application and nothing more. Therefore, section 14 does not involve an adjudicatory process or points raised by the borrower against the secured creditor taking possession of secured asset. So therefore, my lord, the document that we filed or rather the affidavit that we have filed, the DM has taken note of it. And in the order they have, the DM has already mentioned those things like default of loan, secured the identity of the party, the identity of the property, In that case, my lord, this order, only that ground cannot be, my lord, set aside. And so far, my lord, the taking possession is concerned, my lord, I again, my lord, harp on this thing that that particular order actually, my lord, mentioning the police authority to take possession along and giving the copy to me for the purpose of taking possession. And the section also states, my lord, the power of the, my lord, the CM of DM is to assist the authorized officer by giving a police assistance for the purpose of taking physical possession. At present, I do not know, my lord, whether they would exchange affidavit or not. The very purpose of my application is this to, my lord, to seek an interim protection, so that, my lord, the content proceeding that I am taking, my lord, that may be no coercive action may be taken. My landed senior must be aware of the content proceeding. Again, another yesterday it was fixed. Again, on 30th, the date has been fixed.
Yes.
Milord, as far as I am concerned, Milord, I am defending only one part of the order. I don't want to take much of my lord's time. My lord, admittedly, certain chronological delay. 2014, I got the sale certificate.
What about Mr. Trivedi, the observation regarding the proceedings under section 14?
14.
Yes.
Lordship, as
That-
far as
if
observation
that is set aside, you get the property?
My lord, if that is set aside, but then, my lord, it should, I am only sufferer due to the delay. Now, my lord, I am at present.
Putting that question to you because,
my lord, that is what was also my understanding. I was asking my learned friend, who himself is regarding this, that if there is a time frame, my lord, if my lord so deems fit and proper, if it falls from my lord, then my lord is going to set aside that order of DR80. And they are entitled to take possession as far as the magistrate's order is concerned. Then, my lord, if in a time frame manner, if we get possession of the property, my lord, then because my whole contention was since 2014 to 2025, I had invested 25 lakhs at that point of time. That was a good amount of money at that point of time. Now, my lord, I have turned 75 plus years of age. Now, my lord, I need that money.
Then the property would have appreciated.
My lord, that I have to take instruction, my lord, but my lord, certainly it must have. Because, my lord, through my common sense, my lord, I may
Where do you get a property for 25 lakhs?
My lord, that is true, my lord.
That property, I am told, runs into pros. I am told.
Huh? My lord,
So far, the submission of my lord senior friend is I concede, my lord.
well,
If
conceding,
directly-
my lord, there is another technical fault which they have committed. The main borrower who has actually obtained this, the person who is in possession, he has, whether he has his heirs have been not substituted as yet.
I already filed an application. I have sent the in terms.
Now,
of the
if
order-
tomorrow my lord passes an order, I don't want my lord to add agony. My lord passes an order, tomorrow they will come, they will say, we were not substituted and you did not assist the honorable court regarding that and we were not given notice, then everything else will go, my lord.
The notice of a notice party is concerned, this is the affidavit of
আপনি
service.
সাবস্টিটিউশন না করিয়ে ওদের এগেইনস্ট অর্ডার করিয়ে নেবেন, ওরা মেইন ডিফেন্ডেন্ট, তারপর তো আমরা আরো ফেঁসে যাব।
They are not here. They are not here, my lord. I have communicated the order. So far, the order passed by the Honorable Justice Sinha is concerned. We have acted in terms of the order. Send the, my lord, repetition copy along with this, my lord, this application was applied.
Anyway, Mr. Trivedi, this was just the first. On the first brush, I thought of it. Yes, you tell me your case.
My lord, what I am humbly submitting is, my lord, whatever is falling from my lord, that is, I also told my client, my lord, that, my lord, our only contention is that whether we get the property or we get back our money, whatever it is, so that I can use that money for my other purposes. Now, my lord, they cannot, my lord, their entire litigation is going on since 2015. If I would have been prudent, my lord, I would have gone back to the learned magistrate, rectified that order and implemented it, because there was only a technical thing. Now, my lord, I am neither getting money. So now, my lord, if that order is set aside and possession is handed over to me in a time frame, in a time-bound manner, my lord, I have no qualms about it.
I am ready.
But, my lord, how his readiness is there, I'm seeing from 2016. 2000 and to 2023, they filed this application before this honorable court. Only when a contempt was filed by us before the learned DRAT, and they were put on notice that rule, then they
You
got
have
this
to serve the borrowers by hand.
Then
We have already
This service will not help. They will come tomorrow. They will come.
then, my lord, what will happen? My lord, supposing my lord passes an order
Tomorrow
behind
they
the back
will
of the
come.
borrowers, again we'll suffer.
I am ready to serve 1 second, my lord.
So
Only I'm
Yes.
seeking for the time being interim protection for the
No
contract.
interim
No, my lord,
protection.
then again it will go for another 2 years.
No interim protection right now. The matter is on the 30th. We'll decide it before that.
My lord, they did not substitute knowingly, my lord, they did not substitute. I have my doubt. They did, my lord,
That was a mistake on our
my
part.
my lord, I am suffering at my money.
Sir, you serve them by hand. Come on Friday. I'll hear you. We'll decide this issue.
This Friday, my lord.
This one.
I will serve once again.
Yes,
Serve them by hand.
my lord, let the, will it be my lord's pleasure to record that order for serving with hand, because otherwise.
Yes, sir. We have to
Yes,
take down. Take down. In the present writ petition, the petitioner is challenging the order dated 2/2/2023 passed by the DRAT in appeal number 263 of 2018, whereby the learned DRAT confirmed the order dated 1/10/2018 passed by the DRT in essay number 158 of 2015, whereby it has quashed the order dated 23/7/2015 passed by the district magistrate under section 14 of the Surfacy Act. The learned DRAT found that the reasoning of the DRT is faulty, however, learned DRAT decided to confirm the order with a different reasoning. Full stop. Learned counsel for the petitioner has impleaded the borrowers, has filed a substitution application, putting the borrowers on record. The service he has filed an affidavit of service. The service shall be effected upon them by hand. Let this matter be listed on Friday. Friday for further hearing. Friday for further hearing. Yes.
I'm
Only one day is there. I'm just wondering whether one day would have helped or not.
Yes, so Trivedi, in this case,
Lordship.
why don't you file a 2-pager written notes so that we can decide it?
Lordship.
Learned counsel for the parties are directed to file a respective arguments, not extending more than 3 pages within 2 days. Monday, we'll keep it on Monday.
Lordship, will it be my lord's pleasure to keep it on Tuesday?
Tuesday.
Because my lord, Monday I'll be again on my next. Sorry, Baba, cannot kuch hai. My lord, whatever falls from my lord.
2 p.m. Tuesday.
Extremely good.
Yeah, just keep this judgments.
I'm grateful.
Keep these judgments also.
My lord.
Tuesday is what? It is on the
29th, I suppose.
29. You're just giving me one day.
My lord, then my lord will keep it on Friday, my lord. I can file it.
Monday, you have a problem?
Monday, I shall be there.
Let's do it on Monday so
My
that
lord, I shall be there.
I get 2 days to decide. Monday. Monday.
My lord.
Whose book, Mr. Trivedi? Your book.
Back with us. Matter number 62.
No, my lord, it is.
It is my lord.
Right, I am appearing on behalf of the respondents.
One Pratap Pandey is the owner of the property. He has granted registered lease in favor of my client. Also, can you look at pages 22. This is municipal tax bill. Poshunendu Chandra Pandey, in the middle, left hand middle of the page. Lordship got it? Page 22, P1. Poshunendu Chandra Pandey, 14/10, Leela Roy Sharadi. Lordship got it? Right. Lordship, next page also, page 23.
Yes.
This is a municipal tax bill 14 by Leela Shorani, Prosunendu Chandra Pandey in black area, amount paid by Pratap Pandey, his son. Now, logically sees page 25. This is the municipal assessment book. Page 25. Owner Prosunendu Chandra Pandey. About 2/3 of the page, 1/3 of the page, left hand side, owner, address 14 by 10, Rila Loyson. Lordship got it? So,
Yes.
Prosunendu Chandra Pandey, Pratap Pandey, they were the owners of the property. And logically sees page 27. The electricity bill, the name of Pritilata Devi, who is wife of Prosunendu Chandra Pandey and mother of Pratap Pandey. Now, let's look at page 28.
What are you showing in the electricity bill?
My lord.
Electricity bill, what are you trying to show?
Page 28, I am trying to show this is a deed of lease, registered deed of lease granted by Pratap Pandey to Khadim India Limited. I am Khadim India Limited petitioner. So by registered lease, the ground floor was let out to me. Logically sees page 31. Total page 31, total area, monthly lease rent 4,42,000. So I am paying 4 lakhs rent per month. Escalation 3 years, and the calculation is there. Now, my lord, logically sees suddenly we received a letter at page 71.
Yes.
Certainly, National Textile Corporation Limited is writing to us. They are saying that NTC Limited, previously known as National Textile Corporation, is the tenant of the property situated 40 by Gorihat Road. There is no existence, my lord. Various litigation initiated by the landlords of said property, namely Sushil Sharma, Rishikesh Sharma, Prafulla Kumar Chaudhary. We don't know who they are. Owner is Pandey. They say they are the owners. Some proceedings issued by landlord Sushil Sharma have been dismissed. So they say you are called upon to stop renovation work, peacefully hand over possession. Who are they? We don't know. Now, well, that's not the end of it, my lord. We replied to them, they give me document how you are claiming tenancy in this premises, and it is a 4 stories building in respect of which portion? Then logic about page 97.
Second notice was dismantled.
Thank you. This is 97. This is joint manager versus logical is Pratap Chandra Pandey, Nandita Bharadwaj. They are the owners of the property. Tenant is giving eviction notice to the landlord. Never heard, but we learn every day. Form a notice on subsection 1 and clause BI of subsection 2 of section 4 of the Public Premises Eviction of Authorized Occupants Act 1971. So under Public Premises Act, some estate officer of NTC is giving notice to Pratap Chandra Pandey, Nandita Bharadwaj, they are the owners of property, and Khadims. And logically, you'll see at page 99, schedule of the property, totally vague. 14 by 10 Gorihat showroom, area, which floor, which area, which portion is a big building, 4-story building, nothing is totally vague. And my lord, today, my lord, my case have summarized at page 8, my lord. of my 8 of the petition.
Yes.
They are the basic grounds, my lord. The respondents claim tenancy under some Sushil Sharma, Rishikesh Sharma, Prafulla Kumar Chaudhary, who were never the owners of the said building. The owners of building were B.C. Pandey, then Pritilata Devi, then Prasunanda Chandra Pandey, and presently Pratap Pandey. So there is a title dispute which is beyond the jurisdiction of Public Premises Act. There came in ownership under some other tenant, and I have seen, Lordship, I am there, I am still in possession on the basis of a registered deed, my lord.
Yes.
So, on this, my lord, Lordship kindly sees. Oh, I'm sorry, my lord. My lord, I'm led by Mr. Mitro, my lord. Mr. Lordship kindly allows.
Sorry, my lord, I was held up before the division bench. No, Mr. Shorter has placed before your lordships, my lord, the facts. Today, your lordship has seen that, my lord, I am in occupation on the basis of a registered deed of lease, which shows, my lord, who are the, my lord, who are the owners of the property who have leased it out.
Yes.
Number one. Number two, my lord, the document annex shows that a possession was given to me.
Yes.
Not today. Number three is, my lord, that I have shown, my lord, documents that renovation works were carried out by me, my lord, in the property in question. No whisper. Then, my lord, comes their letter. Kindly, your lordship has seen, I understand your lordship has seen the letter. Kindly come to the letter once.
Yes.
Kindly come to, my lord, the page 71. NTC Limited, previously known as so-and-so Limited, is the tenant of the property situated at such and such various litigations were.
Which page are you reading?
Page 71.
71, yes. Yes.
NTC Limited, previously known as such and such, is the tenant of the property situated at 14/10 Godiat Road. Various litigations were initiated by the landlord of the said property, so-and-so, so-and-so. Some of the proceedings initiated by the landlord, so-and-so, have been dismissed. It is an admitted position that the company is in settled possession and occupation. Admitted position, my lord, pausing here for a moment. Single document not given. They say, they allege that they are tenant. My lord, I could have understood, I have shown your lordship that they have annexed other documents. Not a single document to show that they were tenants or they continued to be tenant as on, my lord, May 2024.
Yes.
There is no explanation as to how, my lord, my client could carry out, my lord, the works there. They do not say that they did not know. Now kindly come to the next part. The said property, NTC showroom at such and such, has been kept under lock and key by the company since the company is not conducting any operation at present. So tenant, my lord, rent is being paid.
Yes.
No document. Next, my lord, I respond to this. No. Interestingly, we have kindly come to the last, bold portion. It is observed that you have been unlawfully opened this showroom. They admit I am in possession. We have submitted a request letter, etc., etc. We are also in the process of legal action against you. Considering the above, you are called upon immediately stop the renovation work, peacefully hand over possession. I give reply, they don't respond to it. My reply is at page 72. I am not placing this before your lordship. Possibly this has been placed. Now kindly, oh, I give all the details. Sorry. Page 72, my lord, I have given all the details. They don't, my lord, deal with this later. Kindly come to page 73, third paragraph. It is stated that since
Lordship got that?
Yes.
Page 73. It is stated that since the company NTC was never in possession or occupation of the said property, again, no document, then kindly come to my lord page, what they give is page 76. Kindly come to page 76. This is to bring your notice that premises NTC Godihat showroom is encroached and under your possession. The right, title and interest is being vested in National Textile Corporation by virtue of Textile Undertaking Nationalization Act 1972, 95 and subsequently amended in 2014. The corporation is the Government of India undertaking. Now pausing here for a moment, again, no document. The said property is thus declared as public premises with a central government gazette notification dated such and such within the meaning of public premises eviction of unauthorized occupants act. Now kindly come, they annex this. They annex this, my lord, page 77 is the document. English copy of or English part of it, my lord, is at page 82. No whisper of this property.
Yes.
What do you have to Yes. Now kindly come to page 86. This is at best, my lord, they can try to show rented show page 86. Clause C. Rented showrooms at Kolkata, College Street, Chandornagar, Godihat. No particulars.
Yes.
Now kindly come back to page 76. In May 2024, we discovered that the above showroom premises locks were illegally broken and all stocks amounting to such and such and fixed assets belonging to NTC removed, stolen and misplaced without any authorization. Your unauthorized entry into the premises constitutes illegal encroachment and trespassing. On the above backdrop, it is clear that you are unauthorized occupant. Under these circumstances, you are hereby called upon to vacate. Please also note that you are failure to comply, etc., etc. Now, my lord, today, with greatest of respect, now, my lord, they have to show that, my lord, they were the tenants. On the basis of which, my lord, tenants of this property, Godihat, my lord, your lordship is possibly aware of, well, it's a vast area.
They are saying that the owners, not tenants.
Sorry, my lord?
They are saying that they are owners of the property, not tenants of the property.
No. Subsequently, they say they are owners.
Yes.
Now, that is contrary to the letter. They are tenant. And the gazette notification speaks of pilot tenancies. Kindly come to pilot page 71. The first notice. I place this. NTC, previously known as such and such, is the tenant of the property.
Yes.
Now, my lord, with respect, my lord, when they say that they are the tenant, my lord, any document, my lord, they have to show. Tenancy, my lord, is a subsisting tenancy, assuming they were tenant, though no particulars is given.
Where's the landlord? If they are tenants, where's the landlord?
Huh? They are parties, my lord.
Why they are not here?
I can give them fresh notice also. No.
Mr. Mitro, if they are tenants, where's the landlord then? Landlord
I
should
shall
be here.
give them fresh notice, my lord.
Give them
5.
fresh
Respondent number 5 is my lord lesser.
Anyway, let me hear from him.
Well, I shall submit before your lordship only on two issues. Well, first of all, National Textile Corporation, it is a tenant in the said premises and it is a public premises. And therefore, National Textile Corporation has applied for appointment of a state officer. A state officer has been appointed. Notice has been issued under the Eviction Act. But they've entered the jurisdiction there. And today is also the date of hearing at 3 p.m., my lord. Perhaps I do not know whether they have attended there or not. But, my lord, my humble submission is this, my lord, that one cannot enjoy both hot and cold at the same time.
No, I am not.
Who is the petitioner, my lord? Petitioner is a khadim in the industry. Now, my lord, they have entered jurisdiction before the estate officer. And now they have come up with an application under before your lordship on Article 226.
If you are there, Mr. Mitro, then you contest.
No, I have not. I'm extremely sorry to say, I may have.
You raise all
these. This is the notice, lordship.
Adjournment petition. What do I do? The writ is pending.
And the Khadims, my lord, they have appeared their appearance on earlier date. First of all, this.
Hey, কি দিচ্ছ ভাই এটা কপি দাও
Lord,
কপি দাও কি দিচ্ছ
আরে এটা তো কপি তো
How do I know?
কপি তো গেছে তোমাদের উপরে
এই প্র্যাকটিস তো ভাই হাইকোর্টে কলকাতা হাইকোর্টে নেই
The main thing is this, my lord, that this application suffers from non-joinder of party also. Though National Textile Corporation is a government undertaking, my lord, Union of India is not made.
Raise all these arguments before the PP.
My lord, with greatest of respect, my lord, there are
State officer can decide all this.
no, he has, my lord, if he has no jurisdiction, I am going into the root of the matter. I am saying, my lord, this dispute, it's a title dispute which cannot be looked into by the estate officer. He has no jurisdiction to decide this. Firstly, if he had jurisdiction, my lord, he can, my lord, decide points.
You have not been briefed. You have already gone before the state.
Yes.
Oh, my lord, kindly look into, my lord, what is, my lord, I understand that is the prayer for adjournment.
My lord, from Roznama, it appears that they have entered their jurisdiction there.
Applicant seeks 2 weeks time to file reply. Written statement filed by the opponent number 1 and 2. Time is granted. You are participating in the proceedings, Mr.
Yeah, may I look into this? May I look into this? My learned friend did not, my lord.
Have a look at it.
And we have got no opportunity, my lord, to oppose. This is the first time being heard by your lordship. And they've come up with this application and they are telling that no documents have been placed before your lordship. We got no opportunity.
I'll relegate you to the PP, the state officer.
No, kindly, my lord. Kindly. It's very unfortunate. Kindly look into.
Yes.
A copy.
Another one is there.
Kindly look into who is applicant and who to sort time. Applicant is, my lord, the joint manager, marketing, National Textile Corporation.
Yes.
I am opposite party.
Yes.
Then, my lord.
Opposite party also seeks time.
May read out.
Yes.
The advocate for the
number 3. Khadim. Messrs. Khadim.
May I now?
Sir, just let him speak.
Lordship.
2 people can't speak simultaneously at the same time. Let him speak. I am saying 2 people can't speak simultaneously at the same time. And I don't need to tell this to senior advocates.
I'm sorry.
If it was some young member at the bar, I would have scolded, said
I'm
something. Senior advocates, I don't even feel like saying anything. Yes, Mr. Mitra.
May I read out? I'm sorry, my lord, I cannot. একটা কপিটা দাও না একটুখানি আরে জজ সাহেব তো কপিটা আমায় দিয়েছেন
This is just one.
Another one. No,
Yeah.
yes, that one.
The next page is not there.
That one fixing the date today, date and time today.
এইটার
That's
একটা
right.
কপি দাও না
এটা একটা কপি দিয়ে দেবে তোর সাথে
kindly look into this, my lord. Kindly look into this. This is what has been given to your lordship. Well, kindly come to the top.
Yes.
Case number ESKT such and such. Kindly see Joint Manager Marketing, National Textile Corporation applicant versus Pratap Chandra Pandey, so and so, opponent respondent. The said case is scheduled. Kindly come to the next paragraph. Applicant present and junior advocate for applicant present. Advocate for opponent number 1 and 2 not present. Advocate for opponent number 3 present. The advocate for applicant 2 weeks time to file the reply on the written statement filed by the respondent number 1 and 2. Time is granted. And my lord, what is referred to?
No, sir, read further.
Yes. Further, as per earlier direction today, the applicant filed reply on the application filed by the opponent number 3 with copy to the other side. The judgment cited in the
So
reply.
you're already there, sir.
Yes, I have taken the objection there. That is the application.
So that will be decided. You have gone before the.
I
state
have said,
officer.
my lord, whatever I am doing is without.
Whatever it is, the state officer will decide that. What is the
No, my
difficulty?
lord, with respect, my lord, kindly consider. Kindly consider. This.
Yes.
My lord, if I go to a higher authority and say that the lower.
You have already gone. You have already gone.
have
You have
gone
moved
and
an-
I have
you have
taken
moved an
time.
application also. Let the application be decided. You come here.
I have taken
You-
time.
You have moved an application. Show me the objection which you have filed.
May I read out the prayer?
Yes, please do.
The applicant opposite party number 3 respectfully prays that the instant case may be kept for abeyance till the disposal of writ petition being WPA number such and such.
So abeyance is nothing.
So that, my lord, they do not proceed with this.
This is Mr. Metro. The day you have got the notice, you could have come here. When you go, submit yourself.
I have filed the writ. I have filed the writ.
I feel, Mr. Metro, you should go before the state office.
My lord, I have filed the writ, and thereafter, my lord, I have, my lord, brought that to the notice of, my lord, the estate officer and say that don't proceed with it. Now, my lord, kindly appreciate today, my lord, forgetting about the estate officer.
Yes.
My lord, a district court. My lord, if I say, come up before your lordship and say that this district court does not have jurisdiction, my lord, that district court will not decide that.
No, it's not about the jurisdiction of the district court. They have,
Yes, absolutely.
in the Public Premises Act, they have the jurisdiction. They can very well decide this issue.
My lord,
Whether and the landlord as well as you
yes,
can very well go before the Public Premises Officer and can get this issue decided. And the rest of it, as far as the who's the owner, who's not the owner, and what is happening is for the civil court to decide.
my lord, may I,
Yes.
my lord, rely on a judgment, my lord, that, my lord, the
Show me.
disputed question, my lord, the estate officer cannot go into.
You show that to him. He's not decided anything. You take all your points and contentions will be open before the state officer. I'm not passing any orders as far as the state officer is concerned. The rest you can show whatever judgment you want to show.
Huh? My lord, kindly, may I rely on এত মোটা কেন? 2019 volume 20 Supreme Court cases, page 705.
Yes.
My lord, kindly come to paragraph 47 directly.
Yes.
The question involved in express newspaper case in relation to remedy of the state co person in possession of the land was again considered by a bench consisting of 3 judges in state of Rajasthan versus such and such. In that case also the question arose as to whether the state government can take recourse to a summary remedy of eviction of a person under the state revenue laws from the land when such person raises a bona fide dispute about his right to remain in occupation over such land. Their lordships held that in such a situation, the summary remedy to evict such person under the act could not be resorted to. In such and such, Justice so-and-so speaking for the bench held in paragraph 6 and the following words. As noticed earlier, Section 91 of the Act prescribes a summary procedure for eviction of a person who is found to be in unauthorized occupation of government land. The said provision cannot be invoked in a case where the person in occupation raises bona fide dispute about his right to remain in occupation over the land. dealing with similar provision contained in Section 6 of the Andhra Pradesh Land Encroachment Act. This court in state of AP versus so-and-so has laid down that the summary remedy for eviction provided by Section 6 of the said Act could be resorted to by the government only against persons who are in unauthorized occupation of any land which is the property of the government, and if the person in occupation has a bona fide claim to litigate, he could not be ejected save by due process of law, and the summary remedy prescribed by Section 6 was not the kind of legal process which is suited to an adjudication of complicated questions of title. For the same reason, it can be said that summary remedy available under Section 19 of the Act is not the legal process which is suited for adjudication of complicated question of title, where the person sought to be evicted as an unauthorized occupant makes a bona fide claim regarding his right to be in possession. In such a case, the proper course is to have the matter adjudicated by the ordinary course of law. Then, my lord, kindly come to lastly, my lord, paragraph 59.
Yes.
Yet the last submission of the learned counsel for the respondent that the writ petition was not maintainable to challenge the notice issued under Section 4 of the PP Act has no merit and deserves rejection. Suffice it to say, firstly, the High Court having entertained the writ petition and dismissing it on merit, this objection does not survive for consideration. And secondly, in the light of long line of decisions of on this question, a writ petition to question the legality and correctness of the notice issued under any act is no bar in entertaining the writ petition in appropriate cases. The case at hand was regarded as an appropriate case for entertaining the writ petition. Now, my lord, in view of this, my lord, kindly decide the jurisdiction. Let them file affidavit if they want to. Let them show, my lord, how they say, my lord, that they are the tenant.
No,
Their basis is, my lord, that they are the tenant.
You go before the state officer. Take down. The petitioner in the present writ petition is being aggrieved by the impugned notices dated 17/12/2024 and 18/1/2025 issued by the state officer, whereby the respondent number 1 initiated proceedings under Section 4 of the Public Premises Act 1971 for the eviction of the petition. Next, it is the case of the petitioner that he carries on his business as manufacturer and retailer of shoes from the premises in question at 14/10 Gariahat Road, Calcutta. It is his further submission that the respondent number 5 is the absolute owner of the said 4-story building, and the petitioner is peacefully occupying the said premises under virtue of a registered lease deed dated. What is the date of the lease deed?
Sorry, my lord, date of the
lease deed.
Oh, I see. Kindly give me a minute's time. 15th March 2024.
15th March 2024. Full stop. However, all of a sudden, the petitioner received a notice dated 30/5/2024 from respondent number 4 informing the petitioner that the respondent number 1 is the lawful tenant of the premises in question from 4/4/1971, and it was under their lock and key. Full stop. Various litigation are pending between the landlord and respondent number 1. Since the respondent number 1 is not conducting any business, the said premises is kept under lock and key. Lock and key of respondent number 1. Hence, the respondent number 1 asked the petitioner.
May I have your lordship's leave, my lord? Mr. Shorkar is here. I am obliged.
Asked the petitioner to stop the renovation work being carried out at the said premises. Petitioner had replied to the said letter letter dated 11/6/2024, full stop. However, no response is received from respondent number 1. Instead, the respondents initiated proceedings under Public Premises Act for eviction of the petitioner from the said premises. By show cause notice dated 25/10/2024, the respondent number 1 informed the petitioner that the right, title, and interest for the premises in question is vested with respondent number 1 by virtue of Textile Undertaking Nationalization Act 1972 as amended up to date. Full stop. The premises in question was declared as a public premise by Government of India by notification dated 9/11/2012. In view of the same, respondent number 1 had asked the petitioner to vacate the premises in question, failing which PP Act proceedings shall be initiated. Full stop. The petitioner represented by reply dated, the petitioner had replied to the said notice. Full stop. However, the state officer appointed under the PP Act initiated proceeding for eviction of respondent number eviction of the petitioner from the said premises and had issued notices dated 17/12/2024 and 18/1/2025. Full stop. Being agreed by the said notices, the petitioner has preferred the present writ petition. Having heard the parties and after perusing the documents on record, this court, full stop. This court has heard the argument of the parties and has produced the documents on record. Full stop. The respondent number 1 is claiming his right, title, and interest qua the premises in question by virtue of the Textile Undertaking Act 1972 as amended up to date. Full stop. Further, the premises in question has been declared as a up to date. Full stop. Further, the premises in question has been declared as a public premise by Government of India notification dated 9/11/2012. Full stop. There is no document on record to show that the said notification was ever challenged by the landlord or the petitioner. Full stop. In view thereof, this court is of the prima facie view that the premises in question is a public premises, and in order to evict an unauthorized occupant from the public premises, the procedure as prescribed under the Public Premises Act 1971 is to be followed. Full stop. As per the Act, the statutory appeal lies against the order of the statutory appeal lies against the order of the as per the Act, the state officer has issued the show cause notice. Full stop. Since this court is of the prima facie view that the premises in question is a public premise, this court is not inclined to interfere with the proceedings initiated by the state officer for eviction of the petitioner. Full stop. The petitioner is free to appear before the state officer and raise all his objections and contentions before him. Full stop. The state officer is at liberty to decide all the objections and contentions of the petitioner in accordance with law. With the above direction, the present writ petition is dismissed.
So Lordship records the judgment you have cited, man.
उसमें एक line पहले लिख देना. The counsel for the Mr. Mitra, the senior counsel for the petitioner, has relied upon the judgment of 2019-20 Supreme Court 705. The facts of the same are not attracted in the present case and are distinguishable. The present writ petition is dismissed. Take this. Yes. उसमें एक लाइन और ऐड कर देना. It has also been brought to the notice of this court that the petitioner has already approached the state officer and has filed his application and objection. Full stop.
No, my lord, we have not filed.
Has already
We have filed a preliminary objection about jurisdiction.
has already approached the state officer and has filed his preliminary objection.
Maintainability application.
Has filed his preliminary objection regarding the maintainability of the proceeding before the state officer. The state officer is at liberty to decide the same in accordance with law. No opinion is expressed on the merit of the matter. Full stop. With the above observation, the present writ petition is dismissed.
This application is disposed of.
Yes, it's dismissed.
Item number 63.
My lord, item 63, I am for the petitioner.
Yes.
My lord, item 63, I beg to appear on behalf of the petitioner, my lord.
Yes, Mr. Krishnendu.
My lord, this matter relates to non-disbursement of family pension to the widow of a freedom fighter. Now it governs under Swatantra Sainik Sanman Pension Scheme 1980. Lordship, kindly take trouble to turn to page 38 once.
Yes.
The husband of the petitioner was granted pension under the Freedom Fighter Division way back on 25th August 1986. Now in the middle portion at point 3, your lordship would be pleased to find the name of the petitioner.
Salima Bibi.
Salima Bibi, right.
Yes.
Now, my lord, at page 39 also, the pension order shows on the right-hand side. My lord, kindly take it in the landscape mode. At point 2, Salima Bibi's name appearing. My lord, got that? It's a pension order. Sri Taimur Ali Shah. He was the freedom fighter.
May I make a submission?
Yes. The learned ASG is here to assist.
We have got instruction from the Home Ministry dealing with freedom fighters petition case. We are going to allow this case on pension within 6 weeks. Can you record?
Mr.
There are so many things we could have.
Bhattacharya.
My lord, I am grateful to
argued on merit
by additional Solicitor General, but at the same time, my lord, kindly consider the plight for having family pension has been for the last 9 years.
That's
Now,
all right.
her husband died on 24th June 2016. 9 years ago.
Merit, I have something to say.
9 years.
You want to put
she
a
has-
you want to put a quietus to this issue, or you want to agitate?
As I said, I'm
you know it
grateful.
much better. You want to agitate, they'll come, they'll file their reply 4 weeks, 6 weeks, 10 months, few more years. What do you want?
I leave it to your lordship's kind consideration. It's 6 weeks and with the interest that has been active.
The petitioner in the present writ petition is aggrieved by the inaction on part of the respondent in not granting the dependent pension arising out of Swatantra Sainik Samman Pension Scheme 1980, formerly known as Freedom Fighter Pension Scheme 1972. Full stop. It is the case of the petitioner that her late husband, Mr. Taimur Ali Shah, was a freedom fighter and was in receipt of the pension under the above mentioned scheme. Full stop. He expired on 24/6/2016. Full stop. However, despite repeated representations and follow-up, the respondents failed to extend the benefit of the said scheme to the petitioner, to the widow of the petitioner, to the widow of late Taimur Shah. Taimur Ali, what's his name? Taimur Ali Shah. Full
Yes,
stop.
my lord.
Being aggrieved, the petitioner has preferred the present writ petition. The learned ASG at the outset only submits that they shall
On
release-
instruction,
on instruction submits that they shall release the pensionary benefits to the petitioner within a period of
6 weeks.
6 weeks. In view of the statement made by the learned counsel, learned ASG shall remain bound by the statement made before this court on instruction. Learned ASG shall remain bound by the statement. made on instruction.
My client will be bound by this statement.
That's
on
on
instruction, you are
On
lost.
instruction, that's why I'm writing on instruction. On instruction. Full stop. In made on instruction. Full stop. In view of such statement, learned counsel for the petitioner does not wish to press the present writ petition. The same is disposed of in terms of the statement made before this court, and the pensionary benefits shall be released to the petitioner as stated before this court within a period of 6 weeks from the date of communication of this order.
Affidavit of service.
Affidavit of service is taken on record. With the above direction, the present writ petition is disposed of.
Item number 64.
Well, at
64, my lord,
my application.
But I appear for the respondent bank.
Yes.
Today in the afternoon, I have received the instructions from the bank to appear. It appears that they have issued a notice to the bank.
This
I mean,
there is a direction to file affidavit.
I'm in some difficulty today, my lord. Your lordship takes it up on Friday, my lord.
Well, can you see the order? Earlier occasion, there is a direction.
You have implemented the third party?
Yes, my lord.
Yes, my lord. I beg to appear for the added respondent, my lord.
Yes.
Only today morning we have received the brief, my lord, from the client.
Learned counsel for the bank seeks further time to file a report by way of affidavit,
My lord, one more indulgence, my lord.
along with supporting documents disclosing the date of handing over of the physical possession of the along with supporting documents disclosing the date of handing over the physical possession of the property to the petitioner. Full stop. Yes.
My lord, perhaps they have filed a supplementary affidavit, my lord. That copy has not been served upon us.
Because that is no way connected with them, because this is an entire issue. I shall serve it. Entire issue between bank or with us. Because this is a question of physical possession.
Counsel for the respond number. What is the new respondent, added respondent?
We
private respondent, my lord.
private respondent নাম্বারটা একটু বলো আমরা
বলে দিচ্ছি
নাম্বারটা পাইনি
The newly added respondent.
দিয়ে দিচ্ছি তো
Want to file reply?
Yes, my lord.
Seeks and is granted 2 weeks time to file his affidavit in opposition. Reply to the same, if any, within 1 week thereafter, lift after 4 weeks.
My lord, only indulgence, my lord, directed to the bank to serve an advance copy of the reply, my lord.
But I shall serve.
Because earlier occasion there was a direction, my lord. They have not.
वो जहाँ लिखा है ना, the bank is directed to file report with an advance copy कर दे. With an advance.
কবে ডাকলো?
How is it possible you are saying that you have given the property, he is coming here? What is happening?
Because my lord, my lord, story is that we have auction purchaser, we have, my lord, they have given up, my lord, as per my lord, we have
precluded to enter the room. They are forcibly, my lord, without any basis, my lord, my lord,
In the possession notice and thereafter in the supplementary affidavit, they have disclosed that they have disclosed a document wherefrom it transpires that we have handed over possession. They
no,
kept
no, my lord,
quiet
that
after
is not
receiving.
true. After giving a legal notice, they have, my lord, given that without bearing any signature, without bearing any date, they have suddenly, my lord, given a date. My lord, after filing of the writ application, they have handed over that document by ABA. When I sent them legal notice, thereafter, my lord, writ application has filed, and they have given that, my lord, letter that they have handed over the physical possession.
It appears that this is a vacant claim. We have handed over possession. They are agitating this issue after 2 years.
My lord.
No, no. They have taken over possession, my lord. It appears that they have encountered some problem with the private party.
Yes, my lord, I laid by Mr. Basu.
Yes.
My lord, in this matter, my lord, the supplementary affidavit that has been filed in the court, my lord, I am, my lord, fortified with a judgment of the Honorable High Court, which says, the Allahabad High Court, which says, and in which, my lord,
Mr. Basu, first you have to clear your stand. How is the third party right created? You have already stated that you have handed over the possession of the.
but that exactly, my lord, I'm trying to answer your lordship's query, my lord. I'm duty bound.
Answer it in the affidavit. You have not filed the affidavit.
As you lord. My lord, I'm for the petitioner. my lord.
Supplementary.
You are for the petitioner or the. It's.
I'm for the.
I am for the petitioner. He's for the bank.
Who your Mr. Basu is leading you?
Yes, yes.
Yes, Mr. Basu, tell me.
My lord, this supplementary affidavit, my lord, that suggests, my lord, clearly the manner in which the bank says, my lord, that the possession has been handed over to them, to my client. My lord, that is absolutely, my lord, erroneous proposition, because I'm favoring with the judgment, my lord, because the Allahabad High Court, my lord, my learned junior is here. I am requesting to hand over.
Basu, let them file their report. Then we'll see that.
Yes, my lord. But in addition to that, my lord, may I pray one thing, that during the subsistence of this litigation, my lord, apart from my client, my lord, the bank will not, there are other interested parties, my lord, they will not create anything which is prejudicial to the interest of the petitioner, my lord, because I have already paid, my lord, more than 1 crore. The bank had, my lord.
I don't know about that. We'll see that. Let the bank file their report, then we'll see if they have created any third party. Because I guess they have created a third party. The order records that. The initial order of Justice Sinha, if you see that order, it already records that there's a third party interest which has been created.
The Honorable Supreme Court says, my lord, it is the duty of the bank, my lord, of late the decision, Mr. Ornava Ganguly is armed with the judgment, of late 2024 judgment.
We will see that. We will see that, Mr. Basu, but you are well aware that the last order has already recorded that. I can't give a finding contrary to the first order.
As your lordship pleases.
Great. Next.
Matter 65.
May it please, Lordship.
In this matter, I am for
My lord, there are 48 petitioners, my lord, before your lordship. My lord, they are all shopkeepers, my lord, situated at Mamra Bazar, my lord, falling under the jurisdiction of Asansol Durgapur Development Authority. My lord, there are 48 petitioners, my lord, before your lordship. My lord, from pages 27 to 75, my lord, are there valid, my lord, documents with regard to the nature of business that they are carrying forward, my lord, which has been issued by the said corporation. Now, my lord, they have been shopkeepers who have been present there for the last 30 years. My lord, the first attack which has been done by the ADDA, my lord, is when a notice for eviction was issued by them. My lord, challenging that, we had approached this honorable court. Lordship, may kindly takes up page number 76 of my application.
Yes.
My lord, this is the order dated 16th of February 2023. My lord, I'm just placing it. My lord, at that point of time, only 7 writ petitioners had come.
Mr. Mukherjee, you already have a couple of orders in your favor.
My lord, 3 orders are there.
3 orders are there.
In my favor. Now, my lord, what has happened, my lord, in all 3 orders, this honorable court is on the same tune that you have to give an opportunity of hearing and you have to follow the law, where the 2 laws requires that there has to be a show cause, there has to be a reasonable opportunity of hearing. Now, my lord, what they do to, my lord, bifurc, or rather, my lord, to give a go-by to the orders which have been passed by this honorable court, my lord, they have now given a tender for the development of the Mamra Bazar area. Now, based on that tender, to the highest bidder, they have given the work order. My lord, now they have, my lord, started the work, or rather, my lord, they will start the work, and now, my lord, there are inaugurations. Everything has been held last Sunday. My lord, in these circumstances, whether any of these orders, my lord, which has been passed by this honorable court, my lord, whether they will be able to comply or not, because, my lord, any hearing which they will give to me, my lord, will become a farce.
It will not. You are absolutely wrong. They cannot do anything. They can't go ahead with it unless until they comply with the due process of
My
removing.
lord, they have gone ahead with it.
They have not gone ahead.
My
They
lord,
have only issued tender. They have only got the bidder. The bidder cannot start the work unless until
My
he
lord,
follows the due process of law.
lordship will seize, my lord. My lord, I'm showing to your lordship. My lord, now this is the recent.
Anybody has been anybody's property has been demolished.
My lord, my lord, what they have now started doing, my lord, they've taken measurements.
They can't do it. Let them take measurements. Measurement, there was an order where it was stated they can take measurement.
Now, my lord, I'm showing to your lordship.
Of the three orders, it is already stated they can take measurement.
My lord, of the last order, my lord, where yes, my lord. In the last order, my lord, it was our point that they had taken measurements, and my lord, in that they said that whatever they do, they should follow the process of law.
Even the last order dated 10th
Mr.
of March
Mukherjee,
2025.
premature doesn't make sense.
But only one reason, my lord, why we had approached this honorable court, my lord, is big.
You are nowhere affected by invitation of a tender.
But they've given inauguration, my lord.
They can do anything, but they can't remove you till the time.
My lord, when your lordship, my lord, kindly specify.
I'm not going to specify it. You are already protected by 3 orders of this court.
But over here, my lord, lordship
You
sees.
can't do it. If they come, if they do it, you come to the court. But today,
17th April, lordship sees.
Sure, sir. Let them do something. They have only done the measurement in terms of the order which has been passed by this court.
No, my lord,
They have not done anything which is contrary to the order of the court, and the notice inviting tender does not affect you.
They have given the tender. They have given effect.
Good. It doesn't matter.
Work order issued now.
Doesn't matter. Mr. Mukherjee, how does it matter?
My lord, then your lordship, my lord, liberty, my lord, then may be given, my lord, to come at the appropriate stage, my lord.
The petition in the present petition is challenging the e-tender notice dated 28/2/2025, released by the respondent for improving and
My lord, only one humble, I'm so sorry, my lord, during your,
Mamra
my lord, only one humble, my lord, prayer. My lord, let it be, my lord, recorded subject to your lordship's name, my lord, that the other previous orders, my lord, would be followed by them.
Mamra Bazaar, main road from parallel road to JL Avenue within DMC area, Durgapur, Paschim Bardwan. It is the case of the petitioner that their shops are situated at said area where the respondent municipality is intending to widen the road. Full stop. These shops are in existence for the past 40 years. Full stop. However, petitioner alleges that the respondent municipality is trying to evict them from the said premises without following the due process of law. Full stop. It is the submission of the learned counsel of the petitioner, Mr. Mukherjee, that earlier also the respondent municipality had tried to evict the said shop owners by giving them notice, and one of the shop owners had approached this court in writ petition
Only
number
one thing, they started work on 28th of April 2025.
3241 of 2023, comma, and this court by order dated, where's the order? First one.
Well, page numbers 76, 77.
To 2023. Quashed the said notice. Said notice granting liberty to the respondent municipality to proceed in accordance with law. Full stop. Hence, the respondent municipality again issued notice for eviction, comma, that too was also quashed by this court by order dated 3/7/2024, granting liberty to the respondent municipality to.
My lord, it is respondent ADDA, not the municipality.
ADDA, my lord.
ADDA.
Asansol Durgapur
Development Authority.
ADDA to proceed in accordance with law. Full stop. Learned counsel further points out that the order dated 10/3/2025 passed by this court in writ petition number 5 to, which is the last one?
Page numbers 80, 81, my lord.
5245 of 2025, wherein this court had disposed of the said petition with the observation that the respondent ADD, whatever, is entitled to remove the unauthorized occupants from the public premises, but strictly in accordance with law, full stop. Now the petitioner is apprehending that the respondent so-and-so is going to evict them from the said shop without following the due process of law.
As work
As
starts
they
from
have
20th
already
April.
issued e-tender for widening the road, full stop. The said road widening activity cannot be carried out without it is further submitted that the said widening of the road cannot be carried out without evicting the petitioners, full stop. This court has heard the argument advanced by the counsel for the petitioner and has produced the documents, full stop. Admittedly, the petitioners are sitting on public land belonging to the respondent ADD so-and-so, and the petitioners are unauthorized occupants, full stop. Respondent municipality is well within their right to evict the unauthorized occupants from the said site, but only after following the due process of law. In the present case, the respondent municipality has issued e-tender for road widening, full stop. It is the apprehension of the petitioner that the said tender will affect their, will lead to their eviction, full stop. Since the petitioner are illegal unauthorized encroachers on the public land, the respondent municipality can evict them after following the due process of law as enumerated in the other various orders passed by this court, full stop. Anything else?
My lord, only one thing, my lord, it is not the municipality, my lord, it is the development.
That is.
Anything else?
But that deep regards, my lord. Affidavit of service may be kept on the record. Deep regards.
As of today, no notice has been issued to the petitioner for vacating their shops, full stop. Hence, this court is of the considered view that the present writ petition is premature, full stop. This court directs the respondent ADDA to ensure that the eviction of the unauthorized occupants from their land is to be carried out strictly in accordance with law. With the above direction, the present writ petition is disposed of.
Deep regards. Much good.
Affidavit of service is taken on record. Oh, Chandikar.
ডাকবে ভাই ডাকবে
My Mr. Bhattacharya, both the Bhattacharya.
Both Bhattacharya কিছু বলছে
না না
No, he is my leader.
My staff is saying too much for the day.
too much for a day after passing in this matter. No, so as I believe for Mr. Bhattacharya, not too much for that day, because when he go back to home,
It's for them too much for the day.
no, for him, because he just always asks this. Everything is too much for me, no problem.
Shall we have it tomorrow then?
I don't mind, because since they are in real in trouble, because they are also human being. But question is whether let it be heard on tomorrow. What he's talking about? But normally I don't oppose in the case of adjournment. But here, as I'm told, my friend who is appearing for the government, because they are the person to justify their conduct, they say what they did on 23rd March. I filed this petition, my client filed this petition in Washington Court with a notice to them, government and the private.
Show me the file.
Item number 66. Every service now.
Yes.
Once he said there is no urgency, you must justify why there is no urgency.
Tell me what.
My lord.
Tell me what is it.
So, my lord, on 23rd March, we filed this with a notice. On 7th April, when you mentioned the matter.
Show me what is the content. What are you challenging? What do you want? They have participated in the tender, right?
Yes. Kindly sees the prayer. I think it's an infractions.
Yes,
Let's see.
Show me.
Kindly, first, let me have my say.
Yes, sir.
Whenever a tender is floated, notice in any tender, certain terms and conditions are incorporated. For various reasons, so that the person will participate in the tender, they must know their position. I'm not in a position to compete, so I'll not in the fight. Now here my terms and condition is there, and what job to be performed, that is at page 57.
Page 57.
Kindly come to page 25.
25.
Yes, I'm deeply obliged.
Page 25, sir. Tell me.
Serial number 4.
Yes.
Guskura house gum, such and such, jungle road from such and such to be done. Total value of the estimated amount of 23 crores, 55 lakhs, 42,000.
Yes.
Now, kindly take the terms and conditions at page 27, which is very relevant.
Yes, sir.
Work credential.
Yes.
Have you got it, my lord?
Yes.
The prospective bidder shall have satisfactorily complete as a sole firm. Kali marked is very relevant. Sole firm, not as a subcontractor, during the last 7 years as such and such, and the minutes meeting such and such at the chamber of such and such, the automatic. So the whole thing is this: that well, they must show that well they have completed this successfully as a sole firm.
Yes.
Now, my lord, and there is a 40%, my lord, other things. Then kindly come to NB, Marks NB, Roman 3 at page 27, last paragraph. In Roman 3. Have you got it, my lord?
Yes.
I'm sorry.
No, tell me. Yes.
Credential certificate issued by the executive engineer or equivalent or competent authority of state, central government, state government, undertaken 70 amounts of body constituted under the state of such government will be taken as credential. That's all. Then kindly see the last line. However, credential certificate issued to subcontractor by central or state government undertaken competent authority shall not be accepted. This is very relevant. When some participant come with that, yes, I've collected the certificate as such, my status is like this, it will not be accepted. Then kindly come to page 32.
Yes.
Small c, serial number 4, then please come down. Small c, conclusive proof. Because to perform this job, have you also got it, my lord? I'm deeply obliged. Conclusive proof of ownership, tag invoice, waybill, delivery challenge for each plant and machinery in working conditions shall have to be submitted. Why this condition is imposed? For obvious reasons. Suppose a contractor, he got the order, then he hired some machineries. If there is a dispute between two, my work of the government will be affected. So you must show that well, you are the owner of the machineries. This is a very vital aspect. Then, my lord, financial aspect.
Yes.
Kindly come to page 57. 57th. The full of irregularities, my lord, and I do not know why he has been obliged ignoring all these things. This is the form, page 57.
Page 57.
Page 57. This is the form. I'm sorry.
Yes.
Have you gotten, my lord?
Yes.
I'm grateful. This is actually the form. And format. Format for lease agreement to be notarized. Now kindly come to, I'm sorry.
Yes.
77.
Yes, sir.
Very interesting. Annexure 777.
Yes.
Kindly see, this is an agreement for sale. Kindly come to the next page, 78. Where is his name? The person against whom I have come here to knock the door of your lordship's final court to have the justice. Where is his name? And I've corrected this. So who is the man who is pulling the sanction to oblige these particular persons? Every spare mile there is irregularities. In spite of that, kindly see, my lord, why they are asking that time I know. to drag and delay. I never oppose the adjournment. Let them produce the burial, let them produce the record day after tomorrow. I don't mind. I'll not ask for any interim order. Kindly come to just a minute, I'm not yet finished. Kindly come to page 79. Everything is irregular. Everything is possible.
Yes,
Kindly come to page 79.
I'm on page 79, sir.
Yes.
Yes,
Probably the factual aspect. Have you got it, Mahila?
yes.
Financial capability. Clause 2. Which is very relevant.
Yes.
Have you got it? Available liquid assets, aggregated working capital, cash in hand, uncommitted bank guarantee, and the credit facilities should not be less than 10% of the estimated cost to put tender. In this respect, the bidder must attach necessary documents with the application. The bidder net worth or such and such. Kindly come to the next. Kindly come to the next page.
Yes.
Next page, my lord. Total liquid assets.
Yes.
Just down the box. Left side box.
Yes.
Total liquid assets. How much?
121.
Then it's 2.3 minimum. So everything is mess. Every time they have been obliged. And I can assure you, so my client is concerned. Of course, who will come and say, "Hum sabse acha aadmi hai." And naturally, he will say, "By my offer is far better than him." That's why I say, my lord, kindly ask them to produce record by day after tomorrow. It is Bardhaman for 1 hour.
Yes.
If I say something wrong, no, he is mapping for the private beneficiaries. I am talking about the state.
For the private respondent. There is a committee tendering protocol headed by the superintending engineer.
You are appearing for the state.
No, I am appearing for the respondent number 5.
Who's the tendering authority?
Tendering authority is the military committee headed by the superintending engineer. And superintending engineer is the answerable. Lord, I am giving the response. Lord, kindly take.
So who you are not appearing? Are you appearing for the superintending engineer? Okay. Say that. Why you complicate things?
At this late
Let
hours, I
them
don't
produce
want
the
to keep us detained. Admittedly,
Only
what
I
I have started the work. Therefore, no question.
Well, the Supreme Court is very candid.
That
They
is
said, even if you
Sir,
start,
Supreme Court is very candid as far as tender is concerned.
yes.
well, I kindly appreciate one aspect. Defense is taken by my very beloved friend, Mr. Bhattacharya, that well, I have started the work. It doesn't matter.
You had the question of
No. What I'm saying, my dear friend,
Tender is already started, sir. Why have you come so late?
no, not late. That's why I said 23rd March, I filed these applications. And the very same I served the notice. And on 7th April, again I mentioned that my junior had mentioned people with the other charge. So that is also served notice. So very same day work order is issued. Entire thing is matter of ID.
Yes.
27th of January 2025 notice inviting tender was issued. 9 persons participated in the tender. Out of the 9 persons participated in this tender, 7 bidders were technically qualified. Out of 9, 7 bidders have been technically qualified.
Yes.
Out of the 7 technically qualified bidders, one of the bidder, Madan Mohan Mondal, whose name is not figuring over here, he made a complaint saying that some anomalies are there. There is a specific provision in the tender that if you intend to raise any complaint, you have to do it within 48 hours on the basis of the uploading. The clause is at page 37, page 7.1. Kindly have a look at page 37.
Yes. Clause?
Clause 7. Procedure for the suspension of the debarment during the procurement of the process. Initiation of the action, notification of the hearing. Any bidder of the procurement authority on his oath and based on any information made available to him may initiate of the process starting the debarment by filing a written complaint by the starting side. The written application has to be done within the 48 hours from the date of the publication of the result of the technical evaluation bill. Kindly have it. Page 42. In
Yes.
case if there is any objection and the complaint regarding non-legality of the technical bid evaluation by the intending bidder, the authorized person on behalf of the bidders may lodge in objection and the complaint.
Where are you reading? Where are you reading?
Page 42 top. Page 42 top. T.
Yes.
In case if there is any objection and the complaint regarding non-legality of the technical bid evaluation, only intending bidders of the authorized persons on behalf of the bidders may lodge objection and the complaint along with the specific authentic document in support of their objection and the complaint as the proof of the notice inviting authority within 48 hours from the publication of the time uploading of the time of the portal.
No, তারপরে no objection. Complaint will be entertained.
Yes.
Yes.
No objection
After
and complaint
expiry.
will be entertained as well as without any specific authentic document as a proof of the support of the lodged objection and the circumstance.
Yes.
So on the basis of which, out of the 7 technically qualified bidder, one of the technically qualified bidder lodged a complaint against the 5 technically qualified bidder. After receiving that complaint has been considered within 48, subsequently thereafter, and a mirror reply has been given. There was no objection by the notarized, the petitioner before your lordship. Subsequently, when the financial case has been opened, when he found to be, my lord, the L2, then he approached before the authority, saying that these are the, my lord, the anomalies, alleged anomalies, which have been mentioned over there. Since, my lord, the 48 hours is over, so far as the portal has been uploaded and the, my lord, the financial bid has already been opened. The tender committee, my lord, there is a time bound total. So tender committee come to a conclusion that who would be the L1 bidder. Subsequently, my lord, tender after opening of the price bid. When this, my lord, the entire process has culminated to an end, subsequently, my lord, work order has been issued. On the basis of the work order, they have already started executing the work. This is the, my lord, the substance of the matter.
So that means, my lord, even if there is irregularity, there is not a mandate, it is a director. Anyway.
No, but had you lodged any complaint, sir?
No. That doesn't mean my right is gone. Because
your right is always there.
no, my lord, if it is a mandatory, I could understood. My lord, suppose I did not lodge any complaint, but if it is found by the honorable court full of irregularities, my lord will not take any cognizance. Merely because complaint is lodged, let them satisfy there is no irregularities.
File your affidavit.
My lord, instead of affidavit, let them direct the producer records. Because the time bound, my lord, when matter to be heard, then nothing will remain. Let them produce a record.
Take down. The petitioner has preferred the present writ petition challenging the
No, instead of affidavit, direct them to produce the record. Because if the affidavit is
records
fast, matter when it will be appear for the hearing, entire thing will be finished. For 249 days, within 249 days, matter to be completed. So record will be produced.
Challenging the grant of tender to L1 bidder Torsha Construction in respect of notice inviting tender number 04 of 2024-25. Petitioner states that the government of West Bengal had invited a tender dated 27/1/2025 for various works. He is in particular aggrieved by grant of tender at serial number 4, right?
My lord.
You are only aggrieved by serial number 4.
Yes, that is the one.
Aggrieved by grant of tender
238
at serial number 4, which is
my lord.
Guskara.
3A, let me explain. 238, 4C, 88. 2, 3, 4 clauses. I swore that, I placed that.
Sir, Please come to page 25.
Item number 25.
There are 4 works. You are
He
agreeing.
is only concerned with one.
You are only concerned.
I'm absolutely correct. Don't say something which is not correct.
That's what I'm dictating.
This is my fault because as I'm told by Junior
Mr. Ashok Kumar Banerjee.
Baba, thao.
At serial number 4 of the notice inviting tender, which is Guskara, Osgram, Chorapari, Jungle Road, strengthening work under inverted comma mein karte na, which is Guspara, Osgram, Chowpari, Jungle Road from 14 kilometer to 28.5 kilometer, comma, strengthening work under Asansol Highway Division in the district of Paschim Bardwan under RIDF XXX, full stop. Learned counsel for the petitioner has stated, senior counsel for the petitioner has stated that the tender has been awarded without following the due process of law. He states that the allocation of the tender has been done with malice and is an arbitrary action of the respondent. Learned counsel for the respondent seeks and is granted 1 week.
1 week.
1 week time to file his affidavit in state will file.
Why representing the state? I don't know what is going on.
No, who's
Representing respondent number 5.
respondent number 5, who's the tendering, he has issued the tender, right?
Here the tender inviting authority is state respondent.
So you filed your reply.
You have to file opposition. When Learned Counsel is says I am.
Why did you not?
He says I am representing respondent number 5. He said 5, sir.
I have
It is between them, my lord. So long he did
He
not
says I am representing the superintendent engineer. That's what he said.
on record.
His Vakalatnama is on record.
And why
Now you tell me. This is a dispute which you have to sort out. Do you want this court to decide who should represent whom? You talk to the person concerned.
Yes, same instruction.
And after
I'm not dictating anything. The
Instead of
the respondents shall file affidavit within a period of 1 week. Reply to the same within 3 days thereafter. After 10 days. After 10 days?
1 week.
1 week, 1 week.
Well, have it 1 week. Well, have it with the result. Otherwise, we'll have no effectivity. Whatever.
Nothing. I'm not going to pass any order, sir. If you want, I'll decide this application right now. There's nothing.
Yes.
If you want, I can dismiss it right now. You take it and appeal.
As your losses, my lord.
1 week, 1 week, 2 weeks. Sure. Affidavit of service is taken on.
And matter will appear, my lord.
2 weeks, after 2 weeks.
I'm grateful, deeply obliged.
The next matter, Mullah, there was some urgency in the, but tomorrow your lordship is taking original side, Mullah.
Yes.
But if Mullah, the tender is under challenge,
Yes.
last day to submit the bid in item 67, Mullah, is 30th of April, Mullah. Mullah, if it can be accommodated tomorrow, I understand Thursday your lordship takes Mullah original side.
What
See,
we can-
only because it's a tender matter, I'm having to mention at this odd hour, Mullah.
So we'll hear it right now. Where is it? Where are the parties?
68 to Malar, the commissioner is on the threshold, Malar. I may be disposed at any time, Malar. I mentioned it thrice before lordship, Malar.
68, I'm not concerned.
Malar, for
We'll have it on Friday or something. Yes.
Other side, other two.
67.
Hey, affidavit of service to pay.
I'm appearing on behalf of respondent number 1.
Yes, the tender challenges of the oil marketing companies, but all the 3 oil marketing companies are party before your lordship.
My lord, the oil companies are being led by a senior counsel, my lord. He has left at 4:30, my lord.
Oh.
Sir, the court is sitting
Kalki
here.
original side.
The court is sitting here, sir.
My lord, I know, my lord.
Shall we give precedence?
He
to
was
the-
here. He was.
But that is very unfair, the way you have put it. to me.
I'll have to inform Lordship will
No,
kindly give
sir.
us some time. I'll inform him to come back.
This is no way.
Yes.
You can say it in a politer manner also.
My lord will take up.
The way you have said it.
My lord, kindly
is-
takes it up tomorrow, my lord.
Sir, it is not appreciated.
My lord, I'll inform him, my lord.
This is
I
not
request that minimum time, my lord, to inform him, my lord. Lordship will not kindly
No, but the manner in
misunderstand
which
me.
you have put is not appreciated.
No, my lord.
I am very sorry to say.
My lord,
The
extremely
manner
sorry.
in which you have put it
I'm
is
extremely,
not appreciated. You have given me the time. I also know 4:30 is the time.
my lord, I'm not saying that.
Some respect for the court, sir. So sad.
My lord, extremely sorry if some